To take the seats, we want to call this meeting to order. It would probably satisfy some members if I would go ahead and hold Solicitor Pasco in contempt and get it out of the way. I'd like to call this second meeting of the House Ad Hoc Committee to examine the judicial selection retention process to order. Good morning. Thank you, everyone, for coming. If we would, I'd like to rise first for a prayer and the Pledge of Allegiance. Let us pray. Heavenly Father, thank you for our opportunity to serve you today. Give us wisdom and discernment in the work that we do. Thank you for every member here that's represented, every guest. Keep them safe, keep their families safe, and the work that they do. Help us to do it all for your glory. All these things we ask in Jesus' name. Everybody said? Amen. Amen. I pledge
allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
A few housekeeping matters. We are going to have a hard stop today at 2:30. We didn't invent the hard stop last week, and we went 6 hours straight, I think, or a week before last week, I guess. And then, so we're going to keep it a little tighter. We still want to have, thank you, as many questions answered as need be. With the members' consent, we've got name tags. I think Ms. Thayer, was Ms. Thayer here? Did I see Ms. Thayer? I think she was the only member that wasn't here last time with us. And so I'm going to dispense with us all introducing ourselves again unless somebody's feeling an aching need to do so. This afternoon, we're going to continue the discussion on the issue of importance to many, the process the South Carolina House uses or the South Carolina Legislature uses to select judge and retain judges. We've been tasked to deliver a set of recommendations to the membership of the House no later than February 1st of next year. In creating this committee, Speaker Smith requests we closely examine 3 categories. Accordingly, it's my desire to each of these topics we go as we go about our work in the course of multiple meetings. Those categories are how we select judges, how we can help and assist judges after the fact that they are elected, and kind of an overall view of the system. I think particularly there's some interest in the dealings in magistrates court. So feel free to touch on any of those categories or items as we go through. We want to hear all viewpoints. The public may submit written comments to the email address on the agenda. Later this month, we'll have a public input meeting that will begin late in the afternoon and go into the evening to allow those that would like the opportunity to speak to us in person. Today, we will hear from various stakeholders in the criminal justice system. Of course, members may ask questions, but consider again till that guest completes their remarks, and then we'll talk to them. I think we called Justice Kittredge up and down 3 or 4 times to try to work it all in. Also, we received in your packet a letter from the South Carolina Association of Defense Attorneys requesting an opportunity to have members of their organization address the committee. And so we will try to entertain that at our next meeting. As you recognize, looking in the audience, we've got the law enforcement side of things and the magistrates court side and the solicitors today and the Attorney General I saw. So we want to give them equal opportunity, so we will work that in next time. Again, there'll be a hard stop at 2:30. The toughest decision this crowd's make is whether we're going to break for lunch or not. We are not. We'll have a little break around lunch. If you want to call somebody or have somebody deliver you something, we'll try to break around noon. With that being said, anything before I start with our guests?
Mr. Chairman.
Ms. Cobb-Hunter's recognized.
Thank you, Mr. Chair. Just FYI, I have a hard stop at 1. JBRC meets at 1.
Okay.
I'm sure that will
disappoint
you.
I've always enjoyed your questions and commentary, Ms. Cobb-Hunter. Also, I know Mr. Caskey will have to leave intermittently to go to committee meetings also for JMSC. Is that correct, Mr. Caskey?
I'm all ears as long as I can be, Mr. Speaker.
If you leave, it's not out of disrespect, it's out of urgency, right?
Yes, sir.
Okay, good enough. With that being said, we'll first hear from South Carolina's 51st Attorney General, Alan Wilson. He was elected in 2010, currently serving his third term in office. He's a graduate of Francis Marion University and University of South Carolina School of Law. General, welcome you for any comments. Again, we're going to have you speak. We're going to ask questions. I guess, and the audience, just knowing we've got our stop and we've got the folks you've kind of designated to speak, just be respectful of each other to the extent we can. If we get to having so many questions with one person, we may ask you to sit down a minute and let some other folks come. We'll just see how that goes. Thank you, sir.
Thank you, Mr. Chairman. I want to thank this committee for the opportunity for all of us to come here. I wanted to go ahead and say, while I'm here to speak with all of you on behalf of the criminal justice community, I'm also here to talk more globally on behalf of the state. And I'm not going to answer, or I don't presume to have an answer or a prescription for every problem, because there's a lot of people up here who intersect with the criminal justice system differently. And everyone has a difference of a point of view or a difference of opinion. So I'm not going to address every single possible thing that happens in the criminal justice system. I also want to thank this committee because what you're undertaking is not as easy as it sounds. And when people talk about judicial reform, I want to make it very clear that today I'm here to talk about JMSC reform. Okay, JMSC reform is a subset of judicial reform, and there's a lot of components. There's magistrate reform. There's, people are talking about diversity on the bench. There's all kinds of reforms that need to be addressed, and we welcome that conversation, and we look forward to future conversations. But my remarks today are going to be narrowly tailored to how judges are elected and selected. I want to start by saying, when I began this year, I went and met with the Speaker of the House, and this was ahead of the Murdaugh trial, so I was kind of out of pocket for a few months after that. But he and I had a very thoughtful conversation, and a number of you and I had very thoughtful conversations earlier in the year, and a commitment was made that we would have something like this, an opportunity for us to have this conversation. And I want to thank the Speaker for obviously setting up this ad hoc committee, and I want to thank you, Chairman Pope, for chairing it and all the members of it, because every one of you has a stake in this, and we appreciate and welcome the opportunity to have this conversation with all of you. And I want to thank the leadership of the General Assembly in both the House and the Senate. I know that there are people who are more skeptical or maybe more resistant or maybe just have more questions. Whatever corner of the spectrum you come from as it relates to JMSC reform, we appreciate the opportunity to have a productive, constructively critical conversation on how we can move forward. Now, with that being said, I'm not here today to attack anybody that's a stakeholder, whether they're a judge, a legislator, a prosecutor, a law enforcement, or anyone. We all inherited this system that we have here today. This system predates nearly every one of every one of us serving in the public. The system that we have today has produced many wonderful judges. And I'm not going to castigate or diminish their contributions, and I do think the system has worked on a number of occasions. But it's kind of like the analogy I've used. If I told you that the system for flying planes works 85% of the time, or 80% of the time, would we not want to get to a higher percentage of safely landing planes? And so I'm not here today, and I heard last week's testimony, someone made a comment about throwing the baby out with the bathwater. I don't think we need to do that. I don't think we need to burn the proverbial village in order to save it. The JMSC is a creature of the state constitution. It is under Article 5, Section 27. It is baked in there, and the Constitution requires that there must be a JMSC. It requires that you, the legislature, must create a JMSC, and that you, the legislature, shall elect nominations made by the JMSC to the full body. That is all baked in. That stuff can't be changed, and I don't hear anyone advocating for changing the constitutional prescriptions for selecting judges. What we are here to talk about today is that there are ways statutorily that the executive branch of government can be made an equal partner in the selection of judges. That's what I'm here to advocate for. My colleagues in law enforcement and in the solicitor ranks, they may have different perspectives and different ways of approaching this, but my approach today is going to be to tell you, what you already know, that there are three branches of government, okay? We are in a branch of government, and I think Justice Kittredge last week in his testimony, I couldn't be here, I was on the road, but I did listen to it, and I agree with nearly everything he said, if not everything that he said. But I think in one of his responses to a question, he quoted Federalist Papers 51, where Madison talked about in the three branches of government, at least at the federal model, which we hope to emulate here in the state model, that you have three silos of power, three branches that are supposed to check the ambitions of each other. As long as human beings are in government, government is going to be flawed. And what we're asking here today, what I'm asking of all of you, is to make the executive branch an equal partner in the selection of judges. Now, I can tell you why. I'm going to give you a couple of examples in a minute. I'll tell you why, but let me work into that. First, as I travel the state and I have conversations with people, whether it's members of the chamber, your Rotary clubs, your political groups, your church groups, whoever will listen, legal groups, I talk to folks, and while people don't talk about judicial reform as a bread and butter issue at the table, it is something that they are concerned about. And when they have conversations, they do agree there is a perception issue. And so as we address this, as we ask all of you to address it, I want you to focus on our interest, the interest of the executive branch of government, not our positions. Now, I want to explain the difference between an interest and a position. When we met Chairman Pope, I used this analogy when we were in Charleston months ago. The difference between an interest and a position is exemplified by a scenario where two women enter a grocery store and they both reach for the last orange. And they fight over the orange and they ultimately negotiate a compromise where they will cut the orange in half and they will each pay half the price of the orange and walk out with half an orange. The next day they bump into each other and have a conversation only to realize that one woman wanted 100% of the pulp and the other woman wanted 100% of the rind. The woman that wanted the pulp was making a glass of orange juice. The woman that wanted the rind was making marmalade. And had they had a conversation, a constructive, critical conversation about what their interests were, not their position was they wanted an orange. Their interest was one wanted rind, one wanted pulp. They could have gotten both 100% of what they wanted at half the cost. So today I'm here to talk about our interests. Yes, there are positions. What are the qualifications of judges? Who are the qualifications of the members of the JMSC? How long should the members of the JMSC serve? How long or how many positions should be appointed by the governor? Or should they all be? Or should some or portion of them be? Those are all positions that reasonable people can have conversations about and have different points of view and maybe even disagree and we can compromise on. But the interest is this. There's three branches of government. In the process of electing judges, the executive branch has 0% involvement in it. And what we want, those of us in the executive branch charged with enforcing the rule of law, the laws that you all pass, is to have an equal check. And so, like in the orange analogy, I'm here to advocate for our interest. Now, the way the current system works, and it's not a bad system, but it could be a much, much better system. There are 10 members of the JMSC. All 10 are elected by the leadership, 3 members of the legislative branch of government. 6 of them are actually sitting members of the legislature, 4 not sitting. What we want is, and when people talk about judges and how they rule, the one thing I'm hearing from people on the ground is this, is that we feel like if we don't like the quality of the judiciary or the judges or the rulings by judges in particular cases, we can go to our House member and complain. We can go to our senator and complain. But there's 168 other members of the General Assembly. And so really our legislator can say, look, I voted for or against the judge, but that's where their involvement stops. The reason the executive branch needs to have a significant weighted representation in the selection of judges is because everyone votes for the governor, the whole state. And so we have a system where power and control over the selection of judges is consolidated in one branch of government, while accountability for those decisions has been basically expanded. Power's been consolidated, and accountability, rather, has been dispersed. And so we kind of want to couple power and accountability, or we want to put those two together, and which is why we think making the JMSC selection process and adding the governor as an equal partner in this process to represent the executive branch of government. Now, there's some people up here who are going to come and talk to you in a minute, and they can talk to you about their personal experiences. I did poll my office, and I did poll prosecutors around the state to give examples of where they perceived, whether it was real, it was at least perceived, improper influence by people practicing law who also serve in the General Assembly. Now, I'll be the first to say this. The vast majorities of the stories that I've gotten are not representative of the vast majority of people who are lawyers who serve in the General Assembly. And frankly, in my personal experience, the vast majority of lawyers who serve in the General Assembly in both parties have been very easy to work with and very easy to talk to. But it only takes a couple to ruin it for the rest. And I could sit up here today and I could read to all of you all of these anecdotal examples, but I've narrowed it down to just a couple, very, very few. And this will kind of exemplify. I have sanitized the stories to eliminate, so I hope you can't identify who the judge or who the person on the other side was. I don't want to do that, but I want, some of you have asked for examples, you've asked for data, you've asked for statistics and information, so this is me doing what some of you have asked me to do. So recently, I was talking, when I say recently, this past year, I was talking to a CEO of a fairly large company that does business here in South Carolina. The CEO, and I don't want to identify the company, but the CEO is not from here, and this company has a footprint in multiple states. The CEO was telling me the story of how what occurred was this company, in an effort to build relationships with local communities, decided to, because of the type of work that they did, they offered safety courses. This company is a heavily industrial company, and so they train their employees in the type of work that their employees do. They decided to offer training at cost to local municipalities within the footprint of this company's service, right, what they do in the state of South Carolina. And so they offered at no additional charge to municipalities free safety trainings to their employees, their municipal employees who engage in the same type of work that the employees of this company engaged in. And they had done this for 20 years. Well, one of those employees for a municipality took that course, then 15 years later suffered a horrific accident on the job. Not working for this company, not on the company's property, not doing anything on behalf of the company, just had taken a course 15 years earlier. Anyway, this person who had been harmed hired an attorney, and they sued, obviously, the property owners. They sued the people on the site. They sued the company, or they sued the municipality. They sued everyone, and then they sued the company that offered the free training 15 plus years earlier. So right ahead of the trial, the CEO and people flew in from out of state. They had local counsel. They were at the courthouse, and I'm giving you the very truncated version of the facts, but this is what the CEO told me. He says, I'm sitting there, and across the way is the attorney representing the harmed individual, and a lawyer who also serves in the legislature, and I'm not saying which side, but is in the General Assembly, walks in and is actually a law partner with this individual. And at some point, the CEO overhears a conversation. The judge is here. You should probably go out and talk to him. And then the legislator leaves and then comes back a short time later. I don't know if it was an hour. I don't know if it's 2 hours. I don't know what. It was a short time later, and they proceed to have pretrial hearings. And what the people at the company and the CEO tell me is that we lost every single motion. Things that came in we thought weren't relevant were allowed in. Things that we thought were relevant and were defensive of our case were kept out. And we ultimately lost the case because of all of those evidentiary hearings, and we were on the hook for millions and millions of dollars. And the CEO said, here are some consequences of that. We no longer offer those at no extra cost. I mean, they made no money on the training. We ceased and desisted in doing all of that. Other municipalities were upset that we quit doing that safety training for their employees, which they now have to pay for. The other thing is that the CEO left me with this. He says, Alan, we love doing business in South Carolina. It's a great state. It's got good people. It's got a good workforce. But the impression we were left with, and we don't know what happened when that legislator left the courthouse and went and met the judge outside. We don't know what was said. It could have been completely innocent. But the impression was that there was influence on that judge. Not that it definitely happened. That was the impression. So when people ask me around the country, because CEOs talk with one another, they talk about how, oh, you guys are in South Carolina, how are you doing? We're thinking about opening a plant there. We're thinking about doing business there. The CEO says, I say a lot of wonderful things about the state, but I always tell them that story. Because, and I think the term used by the CEO from their perspective, this is not my term, I'm quoting, judicial hellhole is what they qualified it as. Now, I don't think we're a judicial hellhole. I think we have some amazing judges. In fact, the vast majority of judges are amazing. But the perception left was that if you're a business and you see a legislator on the other side, then you're going to get shaken down. That is how they left. I don't believe that is true, but that is how they feel. I don't want people to think that way about South Carolina when they're thinking about doing business here. I want all of your districts to get plants and businesses and companies moving here, expanding opportunity. And so that is one story I tell you that illustrates, and it's outside the criminal justice arena, but it's an important story because it sends a message. By the way, I'm not here today to tell you that changing JMSC, who's on the JMSC, is going to fix all these problems. But it does send a powerful message when the legislature itself owns the perception and says, you know what, you're right. We need to bring the executive branch to the table. Now, here's another story, and I'll make this brief. I was speaking to a group a couple of months ago, and I don't know all the facts on the other side. I'm telling you them as they were told to me. A woman came to me and she said, after we talked about JMSC reform, she says, Mr. Wilson, I have a story I want to share with you. She said, I serve on the Citizens Advisory Council, which is one of the two advisory councils that makes recommendations to the JMSC. Now, I'm going to sanitize this story almost to the point to where it doesn't have the same impact if you knew the full facts, but you'll still get the point. There was a person running for judge who had been an attorney for many years, but nearly all of their time had been in government more as an administrator. They had never practiced law. This individual was running for judge, and their packet, their application came before the Citizens Advisory Group, and the woman that I was talking to said that we reviewed it, and this was a very good person. They seemed very intelligent, but they had zero experience in doing the kind of thing that they were going to be judging over. They had never practiced in a courtroom. They had never had a case in a courtroom. They had never even practiced law. It was more administration and government. So we wrote on it. We wrote a letter saying, you have many wonderful attributes. However, we don't think you're qualified at this time. We recommend you go practice law for a couple of years and then come back, and then we'll be happy to recommend to the Judicial Merit Selection Commission that you should be considered for qualifications as a judge. The woman said they later learned that the JMSC found this individual, and I don't know how many people were applying, but this person was found most qualified and ultimately was elected to the position that they sought. And all the members of this advisory committee were like, wow, I mean, no experience, and they were found most qualified. And that was the perception that they were left with. I'm not going to give you any of the other examples of day-to-day engagement that many of my colleagues will probably talk about because, frankly, I want to give them more time. I don't want to take their time from them. But before I sit down, or before I at least answer some of your questions, is that going back to the interest that we have as the executive branch of government, what would I like to see happen? I think the JMSC, there needs to be equal partnership. You all have created the JMSC as you're required to do under the Constitution, and you all get to have the final vote on what judges are elected to the bench. If you don't like the types of judges the JMSC is putting out, you can vote them down. You should have that ultimate power. You should have that ultimate say. That is a check. The judges should be able to look at all of us, all of these prosecutors up here. They should check our power under the Constitution. We welcome that. We want that. We want that check. What we want is not us, but somebody in the executive branch to offer a check on who gets to serve on the judiciary. We think, and I would prefer, that no current legislators, and this is not a knock on those of you who serve on the JMSC, you inherited this system and you serve honorably. But I think a good system would be one where legislators do not currently serve on the JMSC. My preference is for the governor to appoint, if not all, at least a significant majority of the JMSC members. I think the JMSC would be best served if it was removed from funding under the legislative branch and made a separate standalone commission with separate standalone staff. And then removed out from under these buildings. Let it be a standalone. Let it be in a separate brick and mortar building with separate lines of funding with staff who are accountable to the commission members. And then remove the 3-candidate cap. Obviously, I know that you don't want to vote for have 10 elections, but you guys can set the rules. You can pass laws. I'm not telling you what to do, but I think sometimes there's a perception that there's a preferred candidate and 2 throwaway candidates. I'm not saying that happens. That's what I'm saying people tell me they feel happens. If someone's qualified, let them run. If there's 10 people running and you guys want to say the first top 3 vote getters go to the second ballot and then you choose from that like you do now, that's fine. Make up your rules, but remove the 3-person cap and give everybody a chance to be heard. Give everyone a chance to be vetted and questioned. by the legislative branch. And then obviously, I think term limits, if I understand, are coterminous with the appointer. Obviously, if y'all change the makeup of the JMSC, we would like to see term limits. I don't want to see any one person who's not directly publicly elected to be able to sit in one place for 5, 10 years at a time. So I think it would be nice if there was at least a term limit so that there was at least more turnover, or at least an opportunity for all of you and for the executive branch to question the commission members if we don't like the quality of judges or judicial candidates that they're putting out. So removing the 3-person cap. So those 5 things that I just mentioned are things that we're asking you to prayerfully consider as you factor those in. Again, the executive branch of government, these are your police chiefs, your sheriffs, your SLED chief, your Department of Public Safety, your solicitor, your line prosecutor, even your agency directors who aren't in law enforcement. Our job is to enforce the law. We appear in front of the court every day, and the court judges us every day, and they check our power every day, and we welcome that. We want that. We want representation, and we feel like when I'm talking to CEOs around the country, and I can tell them when they're talking about, and they refer to South Carolina as a judicial hellhole, and they start attacking the legislature or lawyer legislators who practice law, I can say, wait a second, this group of men and women in a bipartisan fashion, they brought us to the table to address that concern. And I can sell that when I'm traveling the country, when we're out there recruiting business for the state. I can sell that. I can say my legislature came and they brought us to the table, and they brought accountability to the way that judges are selected. And if you don't like the judges and you think they're treating you inappropriately, then we can at least go to the governor. The governor can talk to the commission members and the general public, the victims. All of us feel like we have representation in the selection of judges. So I want to thank you for letting me talk. I did not read a single word of my testimony because I just wanted this to be organic and authentic. But I thank you for listening to what I had to say, and I know that my colleagues who will follow me will give you a lot of food for thought, but I'm happy to entertain any questions that or comments you all may have.
Thank you, General. I appreciate it. Also, I was remiss, and I appreciate you pointing out that I believe it was you and your office, the bar, the court, Chairman Newton, myself, and the Speaker's office have been meeting since January on this issue, and you pointed that out, and I appreciate it. It wasn't like something we decided to do last week, so I certainly appreciate that. Mr. Caskey has a question, I believe.
Thank you, Mr. Speaker. And Mr. Attorney General, I certainly appreciate you being here. You were somebody that I have known most of my life. Fun fact for those, Alan at one point was my babysitter. So,
and he was an angel, an angel.
Still am.
That explains a lot.
And I say that to say that I'm firmly in the camp of people who have more questions.
Okay.
Unlike perhaps how some in our mercenary media want to portray it, I'm not here to defend the status quo. I am here, though, to insist that we apply rigorous analysis to any proposal that comes forward, and that we do that in a thoughtful way to uncover, as best we can, what realities might then come from the adoption of any of these particular proposals. So my questions are in the spirit of trying to understand how the various proposals and the various logic that has been applied here or been suggested and been applied will help us. And to that end, I guess I will start at the top. I know you framed your remarks as being limited to JMSC, but you touched some other areas with respect to judicial selection models. Do you support judicial elections being popularly done?
No.
Okay. So you're not here to call for us to overhaul then our probate system?
I am here narrowly, I haven't even thought about that, Representative Caskey. I've solely thought about the constitutional scheme that we have to address here today on the selection of judges that have to get approved, qualified, and nominated out of the JMSC. That is, I'm limiting my comments and my recommendations to that.
And I don't want to, I don't intend to have a whole bunch of gotcha questions, but I got questions.
Okay.
And so if you don't support popular elections, then I got to wonder why you would support the election of probate judges like we do now. If you don't want to talk about that, I understand. But I'm going through this again rigorously to figure out what is the problem that we're going to ultimately be able to solve by changing the composition of the JMSC. Because as I understood you, you also said something about, and I don't want to put words in your mouth, something about moving toward the federal model. Is that an accurate summation of what you said your goal would be?
So when I met in Charleston, I was saying I want to go to a model where the executive and legislative branches have parity of power, and the federal model has that. But we are very different than the federal model. We don't have, U.S. senators don't practice law in front of the judges. The judges at the federal system are lifetime appointments. I'm not for that either. By the way, I am not for or against probate judges being elected or other judges being elected popularly. I don't have a position because I haven't thought about it. I wanted to put that on the record. So when I say the federal model, it's the interest, not the position. The interest is I want a system where the executive branch of government is an equal partner in the selection of who gets to be in the judicial branch of government. Right now, we're not at the same table with the legislature. We're not even at the kids' table. We're outside with our face pressed to the glass, and we want to be a partner. We want to be an equal partner in how judges that go through the JMSC are selected.
So you're not advocating a model wherein the governor makes an appointment or appoints a judge subject to confirmation. That's not what you're advocating
No,
for.
that's not what I'm advocating. Representative Caskey, and I'll be clear. I'm not advocating for changing the Constitution. The JMSC under Article 5, Section 21 says that there must be a JMSC, that you all must establish it. You have done that, and that you all elect judges nominated by the JMSC, and you are currently doing what the Constitution requires. The Constitution is silent to a lot of things, the makeup of the JMSC, the qualifications, things like that. We are asking for you to bring the executive branch of government to the table statutorily under the rubric of the constitutional scheme that's currently in place.
And so you would be satisfied with some modification of the JMSC system. Is that fair?
And I've been saying we a lot, and there's a lot of people here who can speak for themselves. I'll say I, but I presume that they will agree with most of what I'm saying, yes. A reforming of the current system. I said earlier, we don't need to burn the JMSC down to save it. The JMSC can exist, but I think that we can reform it statutorily to give the executive branch, make us equal partners with you in the selection of judges that we also have to appear in front of.
I appreciate the clarification, because my concern is that we're going to spend time and effort to make some changes, and then we'll end up in a world where we're back here in some period of time, and folks like you, perhaps you yourself, will say, that's not enough. We should have just done the constitutional change. If that will fix the lack of public confidence that you suggest exists, then I want to make sure that we do that now. Let's not kick the can down the road. So I can take you at your word that some modification of the JMSC process to give the executive branch a voice would satisfy your concerns.
Yeah, Representative Caskey, I think that's an accurate statement that you said. I just want to say that I think JMSC selection of judges is just one component of judicial reform. So if we come back and talk about other aspects of judicial reform, it could be magistrate reform. It might even be the issue with, I don't appear in front of probate judges, that's not my lane, but there may be other people coming up here saying there's other components to judicial reform we need to address. I don't want anyone to say, well, we came and we gave you a couple things, we gave you a couple of slots in the JMSC, we're good forever. I don't ever want that to be thrown in my face. I don't think they want it thrown in their face. So, and again, my colleagues in the law enforcement community and the victims community can speak for themselves, but I would say that it goes a long way. It would go a long way to bring us to the table in this process for selecting judges, and I think it would make a lot of people happy. Now, does it mean that we will be 100% happy with the status quo in other areas? No. I think we're always looking for ways to improve our system of government, but this goes a long way, Representative.
Well, and I appreciate that, because one of the charges that the Speaker has levied for this committee is to consider the magistrate system, for example. And the fact that our magistrates are now effectively appointed by a senator. We go through a process where we say it's a nomination and then an appointment and then a confirmation, but in a practical sense, those people who are not even necessarily lawyers, who are handling the overwhelming majority of our bonds, which seem to be one of the major issues in this state, is not being addressed by anything that you're talking about here with JMSC reform, right?
That's by design. Representative Caskey, I absolutely think we need magistrate reform. I think it's a very broad conversation, but I think magistrate reform it deserves its own ad hoc committee. It deserves its own day in the sun. I think this thing is so broad, the bigger and more comprehensive you get, the more of an ombudsman type package you pass. I think the more problematic it comes, A, to get passed, B, people start sticking all kinds of things in there, and it starts getting watered down, and you get poison pills in it, which is why my approach is, let's start with, if we're going to eat the steak, let's eat it one bite at a time. And right now, today, the bite that I want to take is involving the selection of Family Court Circuit, Court of Appeals, and Supreme Court justices, which are the judges that go through JMSC certification or qualification. That's what I'm focused on today.
Yes, sir, and for reasons that I think are self-evident, I'm focused on one of the three things that the Speaker charged us on this committee to do, which was pay special attention to the magistrate system. I view that, based on the reports I read, based on the conversations I have with law enforcement, that is a significant obstacle in this state to ensuring that we are in a position with an effective criminal justice system. And so I'm not as eager to just brush over that and say, well, that should be a second order concern. And so, and I'm not putting it to you today to bring forward a proposal, because again, I think we will have more conversations about it, but I think we ought to pay a lot of attention to our magistrate system, because we've gotten bogged down on several of these JMSC aspects that are absolutely concerning. And that was the number one thing that the Speaker asked us to look at, and I'm happy to do that. And so I'll leave that to the side, but I certainly invite your participation in that conversation about how to fix our magistrate system, because I don't think we should just rush past that. I do want to go back, though, to a comment you made about you're not involved you're not involved as the executive branch in the JMSC system, sitting at you're not even at the little kids table. And that may be true insofar as you defined the JMSC narrowly as the 10 members who sit in the Gresset building and make votes. But our JMSC system is bigger than that. And I think sometimes it's not adequately explained what the JMSC process looks like to include the Citizens Committee and the Bar's Judicial Qualifications Committee. You do have representation on those bodies, right?
I don't know who all the members are of those specific bodies, but those are not hardwired into statute.
The chair of the Judicial Qualification Committee of the Bar works for you in your office.
And well, what I'm saying, Mr. Caskey, is those are advisory. I mean, again, in my initial remarks, the advisory committee, not the Bar one, but the advisory committee, and by the way, I didn't know I had an employee serving on those committees. I don't have any input into those committees. But a minute ago, I just said that the advisory committee made a recommendation of unqualified, and the JMSC said they're most qualified. So if there are people who in their individual capacities serve on those committees but also happen to work in the executive branch of government, that's not the same as the executive branch of government being represented. That is very different. I do want to say one other thing. You mentioned earlier, and I want to let you get to your second question. I agree with everything you said about the need to address magistrate reform. 100%, Representative Caskey. It is not of secondary concern to me. It is of equal importance as to what we're talking about today. But I came here just because I'm talking about one thing doesn't mean that I don't think it's of equal importance. So I hope that this committee or this body eventually takes it up and that we do pass magistrate reform.
Before you go, Mr. Caskey, that is our intention to deal with the magistrates reform also, and I know a number of the guests are going to touch on that too.
Thank you, sir. Well, it's not only employees in your office. I think some of these gentlemen and lady behind you have folks in their offices who are participating in these citizens committees. But I take your point that maybe those folks don't count as executive participation, but you personally have had opportunity to weigh in on these candidates, right?
The ability to go and appeal to a legislatively controlled commission that selects judges and give my input is not the same as having representation on the commission. To me, I distinguish that. I'm not saying that y'all don't let us come and, talk to you about judges. I mean, of course the JMSC does, and the JMSC does a great job of that. It's just that we, as the executive branch, don't have anyone on that commission that's hardwired into bringing parity of power among the branches.
So, okay, I think You've met with judicial candidates, right? And you have, offered to support or not support candidates at times, I'm sure. Is that right?
Absolutely. I've met with a number of candidates over the years, and they've asked my advice on, the job. And of course, I meet with them.
So then help me then with the problem that I see with part of the argument that I'm hearing, which is that because a lawyer legislator or a legislator sits on the JMSC, there is therefore a conflict of interest or a potential conflict of interest, but that potential conflict of interest would not apply for a solicitor or an attorney general who is on the JMSC.
I'm not advocating to be on the JMSC, I don't know that the solicitors are advocating to be on the JMSC.
Would you be willing to serve on the JMSC? Not your designee, not your appointee, but you personally.
I think that would be ill-advised to put me or my designee on the JMSC, Representative Caskey. I don't think we want a pro-law enforcement JMSC. We want a JMSC that gives the appearance of neutrality and balance of power across the three branches of government. So I would not advocate for an appointment to the JMSC or for me to personally sit on the JMSC, because then you have to invite in the defense bar, and then you start having to weigh all these other purposes. I just feel like it's safer to keep the personalities and the people like the Attorney General should not be on the JMSC. We'll just say that, leave it at that.
Then your designee or the governor's designee, if it's a lawyer, how do you reconcile then the conflict of interest that would arise when that person or his or her partners served on the JMSC?
When you say conflict of interest, I'm sorry, I don't understand.
So insofar as there is a conflict of interest in court, under your argument, that the lawyer legislator then is inescapably attached to, right? Lawyer legislator shows up in court, and judge is affording some deference to the lawyer legislator on JMSC because of his or her status, right? That's central part of your thesis here, right?
That the person serving on the JMSC that would be appointed by the governor would somehow have a conflict with...
Back up. Let's just say, as I've understood you, and please correct me if I'm wrong.
Okay.
As I've understood your argument, the lawyer legislator who serves on JMSC, when he or she...
I'm sorry, I'm cutting you off. I want to take away the term lawyer legislator. Let's just say legislator.
Okay. Well, it becomes, and I appreciate that, because I think there are far too many people who have decided to use that term as a pejorative, and I think it's a profound disservice to the state of South Carolina and to the bar as a community, so I appreciate that. But in this instance, I'm referring to a legislator who then will appear in court. So given that, I've understood your argument to be that that person, when appearing in court, may have some appearance of bias or benefit because of his or her status as a member of JMSC. Is that part right?
I think I understand how you're framing the issues, that you're saying that the same conflicts that could exist with a legislative appointment could still exist with a gubernatorial appointment.
I'm saying that it will necessarily exist. I'm saying that if a legislator who serves on JMSC is tarnished with the appearance or potential appearance of a conflict of interest, that same appearance or actual conflict of interest would attach to an appointee who practices law. And the only other alternative is to either have a individual who does not practice law, or exclusively have people who don't practice law on the JMSC, or to have legislators who are full-time legislators who never appear and can't appear.
I think that's the fallacy of the false dichotomy. You're saying that if you don't do this, then the far extreme will have to happen. I don't think that's the case here. Look, as long as there are human beings in the process, there is no system that exists for electing judges that is perfect and pure and has no politics associated with it. It does not exist. There's not going to be a situation in which you can eliminate every perception of a conflict of interest or every perception of influence. That system does not exist. I want to go back to my orange analogy. Representative Caskey, you're asking really good questions. I think you're right to ask these questions. We're talking about positions, okay? I'm talking about the interest. I want to go back up real quick because I think it's important. The executive branch of government, is there an argument that this executive branch of government shouldn't have representation on the JMSC? And I don't think you're saying that. I think you're getting into, okay, what does it look like?
Well, let me be very clear, and perhaps we'll go step by step to make sure we don't lose anybody along the way. Part of your argument is that a legislator who sits on JMSC who practices law and then appears in front of a judge is tainted with some potential appearance of benefit or detriment because of that status, right? Do we agree on that part?
A narrative could be said about that system.
What about a narrative?
It is a
This
narrative.
is the central argument
Yes,
that you're
yes.
offering. Right. Okay. It's not a heavy fight.
Yeah.
All right.
Well, not fighting, I'm saying that it could be. It doesn't necessarily mean that it will be. There have been lots of people served on the JMSC as legislators. I've never heard their name mentioned once in anecdotal stories of improper influence.
Okay. But insofar as the public has an interest in avoiding some conflict of interest problem, I've understood that to be your argument. And if I'm wrong, please correct that.
I'm going to stipulate to everything you just said and say this. I think the difference is that everyone gets to vote for the governor. And if there is an inappropriate or perceived conflict of interest by a gubernatorial appointment exercising their authority as a member of the JMSC as an attorney appearing before the judges, people can go directly to the governor. But people can't go to a legislator who's not their legislator, who serves on the JMSC. They have no say on that person. But the governor works for everybody. What you're doing is you're giving statewide accountability to who sits on the JMSC by putting the governor's appointments on there. Right now, as I said earlier in my remarks, power is consolidated while accountability is dispersed. And we want one of the branches of government that is most accountable is the executive as it relates to the governor, because everybody gets to vote for the governor. And if the governor's appointed members of the JMSC who are acting inappropriate, then if someone goes to the Judiciary Chairman of the Senate or someone goes to the Speaker of the House to say that you or some other member is acting inappropriate, if that legislator that appoints you on the JMSC isn't in that person's district, there's no accountability. But if the governor hears it, well, everyone gets to vote for the governor. The point I'm saying is accountability. There should be someone that represents the entire state of South Carolina, that everyone in the state of South Carolina can vote for or against, who has a voice on the JMSC. And that is why we're asking for executive branch involvement.
I appreciate that, and I'll move on because I do want to be mindful of our time. What I'm suggesting to you, though, is if you have a JMSC mechanism, which you've said you're okay with, I do not see how you can have a lawyer who sits on that JMSC who does not carry with himself or herself the potential appearance of conflict of interest. I don't see how you can resolve that, whether it is a legislator or the appointee of any executive branch official. And the testimony we heard last week from the experts who joined us by Zoom was that there is no screening commission in America that precludes its members from serving as a lawyer. There's not one.
I'm not advocating for that.
Right. So you're simply, my argument would be, or my question is, you're substituting who the conflict goes to. And I think there is value in having people who are accountable to a constituency, albeit not the statewide constituency, in that position. Because what I hear oftentimes is this lawyer legislator gets preferential treatment. And for reasons that we could spend a whole lot more time talking about, the coverage in the media tends to be lawyer legislator gets preferential treatment. When in fact, in at least one case that came from the Supreme Court, which you argued very well, the solicitor had agreed to that. He had agreed to the resolution that was offered. The solicitor and the defense attorney, who happened to be a legislator, agreed to something that they violated law in arriving at, and yet the narrative is legislator got what he wanted, not elected solicitor got what he wanted. And that's a problem for me in trying to resolve these tensions that we're getting to here.
Representative Caskey, at the end of the day, I can't provide you a solution of people sit on the JMSC where someone's not going to claim there's undue influence. What I can say is we can have a system where the people on the JMSC, or at least a significant portion of them, are answerable to someone who is answerable to everyone in the state, to all constituencies, to all, you can call them special interests, the victims community, the business community, the law enforcement community, whatever community you want to say. And again, when I talk to CEOs and people who want to do business in South Carolina, I do defend the lawyer legislators, but when they tell me a story about that, I want to be able to come back and say, look, I took that story, which I just told you, And I took it to the legislature, and they said, that's fair. We want to create a system where there's at least the appearance that there's parity of power among the three branches of government.
And that's a great vignette that you have shared with us. But I would say to you that we should be equally concerned that those same lawyers who were partner with the legislator, if those individuals are donating thousands of dollars to the solicitor in that case, and then receive a favorable plea deal, we should all be equally concerned about the impropriety. So again, my place is not to say that I'm here to defend where we are now. I'm simply saying we ought to ask questions about how we get to where I think you're suggesting we go, when, you know, this is the only issue I ever see where the black man is accused of being powerful, that the minority party in this state is powerful. You know, it's a strange paradox that we find ourselves in, and I can't understand where the source of that is when I look at our system and I think I, as a member, have one of 170 votes. There are 54 lawyers in the legislature. Any candidate can get elected without a single lawyer vote in our General Assembly. On the JMSC, I'm one of 10 votes. No other member has a greater percentage or lesser percentage than I do on that commission. And these are the tensions that I don't hear resolution of as we go forward. So I'll stop because I know others have questions. I do want to ask you one thing because it's unlikely the speaker will recognize me again while you're here. And I suspect some of our conversation going forward will involve backlogs in the state with the criminal docket. And my question is, in your capacity as the supervising prosecutor in this state, have you identified any concerns with respect to docket management in the state? And if so, what has your office done to ameliorate those concerns?
Do you want me to talk about that here at this committee hearing, or you want to keep it narrowly tailored?
Have you ever, well, because I think the conversation is going to go
what I can tell
to
you is this.
backlog.
Our office has met with Justice James on how we interface with all the 16 circuit solicitors in their offices in the backlog. We do a lot of what the solicitors do, but we do a lot of other things. We do PCRs, we do appeals, capital litigation. We have a whole separate mechanism.
Civil litigation, yeah.
We're the civil side. We're meeting with Justice James, who's our kind of representative on the court, to help us figure out docket management. I went and thank you to the General Assembly for giving the solicitors the docket management software that you gave, the funding for it, rather. We're working with them to try to create a more advanced, technologically advanced system where we can move cases faster, monitor them faster. You've given us some tools that we're implementing right now. So yes, there's an ongoing conversation with my colleagues as well as with the court on how we can make the backlog around the state of South Carolina better. Obviously, as you know, under Langford, the court runs the docket, so we have to go to the court to work to resolve these issues. We can't do it alone. We have to do it with our partners.
And I appreciate that. Let me ask you directly. Have you at any point, or your office ever stepped in the same vein that the Department of Education has ever stepped into a school board that hasn't managed the school system correctly? Have you done anything like that?
I'm not going to answer that question because it goes into matters that may or may not be under review at this time.
Fair enough. Okay, with that, again, my position is I want to get to the same destination you do with respect to the public's confidence in our system. I want to make it crystal clear. I am not married to the way this is. I simply want to keep asking more questions so that we know that what we do going forward will give us the result that we want. So I appreciate your indulgence. I appreciate you being here. I appreciate your service. I'm grateful you're here. So thank you, sir.
Thank you, Representative.
Mr. Robbins recognized.
Thank you, Mr. Chairman. Good morning, Attorney General, and I want to thank you also for your service. That's a very important job that you hold, and y'all do a very good job. And thank you for your thoughts and sharing with us this morning. I wrote down every one of your recommendations. I think they're valid points, and they give us something as a committee to think about and ponder. I just have two areas that I want to discuss with you based on what you said to us earlier. And the first pertains to this phrase of public perception. And I would say to you that I have a question about what you consider that to be, but I also want to commend you because I believe that your office did as good a service to this issue as anybody could have done with the trial that you conducted earlier in the year. I also want to commend you for actually appearing in the courtroom. That'll be a question probably for the elected solicitors later, but you actually participated in the trial, which I think is commendable. But tell me how having that trial on TV every day for 6 weeks or so, where a South Carolina judge was viewed by the entire country, probably some people outside the country, and a trial where justice was delivered, and by all accounts, the trial judge conducted himself honorably, how that particular case did not alleviate any concerns that the public has about any troubles with our judiciary. And I believe, if I'm not incorrect, that the lead defense counsel for the defendant is a venerable member of our state Senate. And as I watched the trial, every ruling went against that sitting senator who was representing that defendant. So I'm curious to hear what this public perception is and try to understand where the public outside of litigants who have been defeated in court is concerned versus the campaign that you and the solicitors and the sheriffs have been waging. If you could help me there.
First off, I want to give full credit to the team that prosecuted the case, and allowing me to be there to be part of it was an honor of a lifetime. And I know that the solicitors sitting behind me, they try cases themselves every single day, and I commend them for representing their constituencies. The answer to your question was embedded in how you phrased it. First off, before I tell you what that answer was, in my opinion, Judge Newman is the gold standard for trial judges. I wish I could clone him and replicate him in every facet of the state. Not because he ruled for us, even when he didn't rule for us in other cases. He's always thoughtful and measured in how he approaches an issue, and I can always see his point of view even if I were not to agree with it.
I would wholeheartedly agree with you.
With that being said, you said the entire eyes of the country or the world were watching that unfold. The whole eyes of the country and the world aren't in every courtroom, aren't in every bond revocation hearing or every plea or every trial in Dillon County or Darlington County or Hampton County. The public doesn't take the same level of interest and focus. And so to me, sunlight is a great antiseptic to inappropriate conduct in the courtroom. I think Judge Newman, had this trial been held in a broom closet with no cameras around, I think he would have come to his same deliberations. I think he would have conducted himself appropriately either way. But for the people, for the judges and or legislators who would choose to exploit or be exploited by the system we have stood up, they're not going to have a camera in every courtroom. Yes, they have what's on the record and transcripts, but you don't have the eyes of the world watching everything you do. And there's something else, Representative, I didn't say this in my opening statements, and I think Representative Caskey mentioned, we need statistics or data, and, you can't just make policy on anecdotes. And I do agree with that. However, sometimes it is impossible to take statistics and data to make a decision. And I'll give you an anecdote to represent that. We all watch football. What about that five-star receiver that never gets thrown to because the defensive secondary, the cornerback, covers them so well they never get a ball? There's no statistic that talks about that cornerback. Or the defensive middle linebacker or defensive tackle who gets around the offensive line, hurries the quarterback but doesn't sack him. There's no stat for that, but the quarterback makes a mistake because they were afraid. Or the other team, the other women's basketball team, has to put 2 additional players on Aaliyah Boston and pull them off somewhere else, which allows other players. There's no statistic for that. There are lots of things that happen every day in the courtroom around the state. I haven't read any of the anecdotes that I was provided, but these are things that you can't define in a statistician's book. This isn't data that you can talk about. They're anecdotal and they're observations. And again, I'm not here today to read them off or to tell you about them, but every day in courts around South Carolina, prosecutors and law enforcement officials see and perceive things that may or may not be inappropriate, but they walk away feeling like it is. And they have no voice, they have no representation on the bench. Yes, our system that we have right now, it has made many fine judges. And a vast majority of lawyer legislators that I have been involved with and my team has been involved with have conducted themselves appropriately. But at the end of the day, the question is, should the executive branch of government have an equal role in the selection of judges that they're in charge of enforcing the laws in front of? And the answer to that question from our point of view is yes. So I hope I addressed your question, but I wanted to add that last little point. It is very hard to give you statistics and data when everything is anecdotal.
I think you did, and I thank you for that. I also want to talk with you about your couple of references to judicial hellhole. And I'm in my 36th year of practicing now, and the only time I've ever heard that phrase was in reference to the early days of my practice when the venue rules allowed any plaintiff to bring a case anywhere they wanted to against a big corporation that was from out of state. And it was common practice amongst the plaintiffs' bar to sue people in Hampton County because that was a great place to get verdicts. And that's what they did. And if my memory is correct, the legislature changed those venue rules some 15, 20 years ago so that that could no longer happen. But I've never heard that phrase outside of that one particular county in that one particular era that has now been fixed. And I would say that we dispense justice fairly across the state for all who appear in those courts. Would you agree with that?
Absolutely, and again, the phrase I've heard hellhole used, judicial hellhole rather, used in reference to that area of the state as well, obviously having tried that high-profile case down there. But this was the term that was used by a CEO who left South Carolina with a perception, real or perceived, right or wrong. It was his words and his perceptions that I'm bringing to you today. And we're not going to be able, changing who serves on the JMSC isn't going to make every loser in a case who loses a judgment or doesn't have the outcome they want. It's not going to make them happy. But I can at least go to them and say, look, the General Assembly, they gave us seats at the table to vet the judges that you and us are appearing in front of. They didn't have to do that, and they did. And I want that story so bad so that I can go, I've given you guys credit. Y'all have created a good system, but it is far, far, far from where it could be, and that's why we're here today.
Thank you, sir. Thank you, Mr. Chairman.
Ms. Cobb, Hunter's recognized.
Thank you so much, Mr. Chairman. General, thank you for your time and,
Yes, ma'am.
and for being here. You've been questioned by two lawyers, so you know this is just a social worker trying to get clarity on all of this. So, General, I want to make sure I understand the tenor of your testimony. What you're suggesting is, and my question to you is whether or not the recommendations you've made to this committee, would those, in your view, halfway cure the problem?
I'm sorry, ma'am.
Do you think two things. One, we're focusing just on, this question is based on your point about focusing just on JMSC.
Yes, ma'am.
And my question is whether or not the 4 or 5 recommendations you made, is it your view that if we did those recommendations, removing the cap, allowing some executive authority, input, that would go a long way in correcting the problems that are out there?
It goes a long way, Representative. It goes a long way in this way. It allows us to say that the General Assembly recognized a perception issue. And of course, both myself and everyone sitting behind me could give you anecdotes and stories of our personal experiences that would support our reasoning. But it goes a long way to saying a narrative that South Carolina wants all 3 branches of government sitting at the table, especially in the election of judges. And I think it goes a long way to solving the problem as it relates to the narrative and the perception.
The example you gave, and would you agree that perception is reality, and whether we think the term judicial hellhole is accurate or not, the fact that there are people out there who believe that we have judicial hellholes, plural, do you think that one of the questions, your point was from a CEO, based on the work that I do, did you know that there are a lot of people in the victim advocacy, victim services community who would agree with that CEO's perception that we literally are in a judicial hellhole in some respects?
Yes, ma'am, and I have a lot of anecdotes from victims too, and I kept in order to give more time to my colleagues and others who are representing the victims community, I would let them speak for the victims. But yes, victims do share that sentiment. And I have talked to victims and I've talked to prosecutors who've said victims are very frustrated.
And I was interested in your comment about relocating JMSC off the grounds, away from the State House. And in your mind, that would serve some kind of, and I'm curious as to what you think relocating the committee will do, especially as we look at considering relocating state offices later today.
Yes, ma'am. I think if you take the JMSC and you allow it to remain where it is, there's a perception that no matter who serves on the commission, and I'm not saying this is what will happen, I'm just saying it's a perception, and it's what people have told me why we probably need to move it, is that the legislative staff staffs the JMSC. So if you want to have a standalone commission where the executive branch and the legislative branch comes together, it needs to be a neutral site where the staff reports to the commission and not to the legislature, but to the commission members rather.
The other, real quickly, because I want to allow others as well to ask questions, I want to go back to the example you gave about again, the CEO who was, this was civil litigation, but there was a conversation, so-and-so is here, go outside, they went outside, blah, blah, blah. But my question really goes to this citizens committee, because there seems to be a lot of stock placed in that committee by some. And I'm listening to your example of the case where the citizens committee recommended that the person go get a bit more experience, that they didn't think they were qualified, and then lo and behold, the JMSC let this person out. So what are we to take from that as far as what value or how much weight does the Citizens Advisory Committee really play in this arena?
Representative, what I took from that is that this individual who served on the Citizens Committee didn't feel like the Citizens Committee really mattered in the process. It's just something that we put there to check a box to make people feel like they're part of the process. What this individual told me was this person, in their mind's eye, based on and I didn't see what other applicants were running at the time. I have nothing to compare it to. I only know the side of the story I was told. I'm being transparent. But what this person told me is that a person that had never practiced in a courtroom is now presiding over courtrooms. And we put that in writing to the JMSC, and that person was found most qualified. I don't know if they were the only person applying or if the other person was worse. I don't know. Or other people, but this person on the Citizens Advisory Committee said it really feels like it's just a check the box stop, that it doesn't really matter what we say, and that this person that was elected to the court was elected not because of what was on the resume, but either who they knew or who they were. And I don't know if that's the case, but that's how this woman felt.
Well, and I appreciate your focus on JMSC. At our first meeting, there were conversations about judges and not having any real documented cases. And from my perspective, and the people who have talked to me, the issue in their mind is not the judge, and I would agree with the assessment of Judge Newman and how he conducted that trial. But the reality from the people I talked to and the people who have reached out to me is that the issue is not so much with the judges as much as with the influence that people believe legislators have on the judges. And so what I'm curious about is how you respond to those who say it is truly a conflict of interest for the General Assembly to appropriate funds for the judiciary, to then select members of the judiciary, and then to have the option, if they want to fire members of the judiciary. How do you respond to those sentiments?
Well, my response to those sentiments is the best way to address it is to divide power and make sure that there's a transparency and accountability in that division of power. And right now, I think there could be more transparency and there could be more accountability in the system. I just think we could do a better job.
And let me just end on the point of accountability. Did you know that well, let me speak for myself. I'm getting a real sinking feeling here that we may be about to experience a similar fate that the U.S. Supreme Court has as far as releasing ethics for justices of the U.S. Supreme Court in a bow to public pressure. Do you have a sense that this will result in, and with all due respect to the speaker and my colleagues up here, do you see anything substantive coming out of this work? And not what you hope. Do you see anything substantive coming out of this?
Absolutely. The fact that we're having
Like
this
they say on Family Feud, good answer.
Yeah,
Thank you.
Absolutely. I'll leave it then.
Yeah, leave it there, Jim.
Yes, ma'am.
Mr. Thigpen is recognized.
Thank you, Mr. Speaker. Thank you, General. Thank you, solicitors, victims advocates, all those who are here and represent your position or your interests as stakeholders in this process. If you are not familiar with me and my approach to things, I try to be measured, try to be objective. I seek to be really more analytical. I tend to lead more towards empirical than anecdotal evidence or subject matter. I think that as we approach this, I would prefer, this is me, a pragmatic approach that really narrows down on what we are truly trying to address. So I have a great appreciation that you narrowly focused in on JMSC. I think that's, again, inch by inch, bite by bite, that's how we get to something. You know, I much like Representative Caskey, believe that good leaders ask great questions. And there's never a question that's stupid. There's never a question that shouldn't be afforded time and opportunity to be answered. So I have a few questions. You answered one of them. I know you made the distinction in your interest versus perception, and you said that legislators do not serve on JMSC. So I want to get clarity on that before I move forward. You are of the opinion, you're making the advice and suggestion that no legislator, whether lawyer or not, have any position on JMSC. And by that, you believe that an executive appointment with legislators ultimately voting provides the separation, the balance. I think you used the word equality too. Is that, did I understand you correctly?
That is my preference, Representative. Again, that's getting more into a positional statement. If there's another way where the executive branch of government is equally represented in the selection of judges that also allows legislative appointments, that's a conversation on the commission. That's a conversation I'm willing to have. But right now, what's baked into the Constitution is you all get to create the JMSC, which you have done, and you all have the sole authority. No one else can vote for judges that come out of JMSC but the legislature. And so you have the ultimate up or down vote on who gets to be a judge, and that is awesome power that that should be retained by the legislature. How else do you bring the executive branch up to the same parity? We should not, and we do not get to vote on the final candidates. So that is why I was advocating for, if not all of the members being appointed by the governor, at least a significant majority, and that is preferable to just one or two seats at the table to check a box. I think the executive needs to be an equal partner. That is what I'm advocating on the interest side.
Right. So let me say something up front, and I promise you to circle back and end with it as well. You know, as we've had these conversations about judicial reform, I've hitched my wagon our caboose to that train to specifically talk about diversity on our bench, that it be a reflection of our demographics. But really, it's a conversation that, I mean, just quite frankly, if we're not intentional about it, not only is it a weakness, I think it is a problem that will create great lack of trust or distrust in our community. Because one of the things that is at the heart of really our conversation is perception, right? And so when we talk about perception, when we talk about trust, when we talk about optics, even though they're not necessarily real and they are perceived, and even though we've heard the statement, your perception is your reality, I do think we have conversations and dialogue about it, even in our agencies, even yours. When we talk about the diversity in your upper ranks and all the agencies, not to single you out, I think that that is something of great interest to me. And I think when we talk about reform, or a word that I'd rather use, improvements, because I think sometimes reform suggests that there is widespread, in my opinion, either negligence or widespread ethics or illegal issues. And I don't think reform is necessarily the correct word, but I digress from that. Let me get to getting off of diversity, talking about the issue I have with where we are now. The issue I have with where we are now, again, you've self-described it as anecdotal, right? That it's not empirical, it's not stats, and it's not data. Former football player, I love the football analogy, but there is a stat for DBs who don't get thrown at. There is a stat that talks about how many times the receiver was targeted because of who was covering them. But that's here nor there. My point is that when you talk about a CEO and a conversation and what he thought he overheard, and it's secondary and tertiary and down the line of not being primary information, and why that I think troubles me most is in a profession as a prosecutor where you find evidence and you make a case, we're having a case being made against legislators that is not factual, it's hearsay, it's anecdotal, it's, and taking whoever this, imaginary CEO may be, and whatever the conversation that could have had, it doesn't speak to specifics. And when we're talking about, and I don't want to use the word overhauling, but when we're talking about fixing a system, I think the threshold should be higher than that. And so then when we talk about this perceived or potential influence that is being placed on a judge, in balance, I don't see, and maybe it has happened, complaints. I don't see anything being levied against. I don't see the argument being made that it's the judge ultimately who has to make the decision. And so if you believe the decision was biased or partial or was not fair, then wouldn't we direct our concerns toward that judge?
So, real quick, Representative Thigpen, I have tried to stray away from going into a long, and I gave you the CEO example as one example to illustrate how a perception in a civil court with a large company that employs a lot of people and invests a lot of money in South Carolina could have larger ramifications for the state. And it is anecdotal, and I acknowledged at the beginning of my remarks that a lot of the things that we observe, you can't write down in a statistic or a data point. I could give you a lot more examples, and the reason I'm not is that there's a lot of men and women who are going to testify to you today with the remaining time who are going, I don't want to take that from them, but what I can summarize and say is this. I can give you story after story after story where people observed direct influence, where a judge had to say, I have to continue the case because of who is on the other side, even though the case is many years old, or that, legislators that are practicing law are acting a certain way in court that if any of us did, we would be held in contempt. And I'm having a lot of, and these, I could go down in the, not just anecdotes, but I can give you story after story after story, and I don't want to do that.
Well,
and by the way, let me say this. It is a small minority of people that do this, but it is very frustrating for a very large community of people who are trying to keep all of us safe. And so what we're saying is that I don't think the prescription for addressing all of the bad conduct that happens in a court is going to be handled by the commission. That's not what I'm saying. But what I'm saying is that by giving the executive branch appointments on the commission, you're sending a signal that we are co-equal partners in the governance of South Carolina. Right now,
Well,
we
let
don't
me-
feel co-equal.
Let me chime in and say, I should have started here, so let me bag up a little bit. I do believe that we're seeking the same goal, and that is advancement improvements to our judicial system. How we're going about it and what I would say is being used as the catalyst to do it, I'm not quite sure if that meets the standard in my humble opinion. And again, I reserve it as my humble opinion. And when I say that, you know, when we talk about, again, who does hold someone in contempt or makes whatever it is, it's the judge. It's not the legislator, right? And so when we talk about even the influence with whether it's a legislator on JMSC, whether it's a legislator in the body period, I would argue we don't know where the influence came from. You can't factually know where the influence came from, if even influence exists. It could be that they were law partners. Could be that they went to USC together. Could be that they're from the same hometown. Could be that they babysitted them when they grew up. It could be a number of things that could create these type of tensions, and I don't know if these tensions can be avoided. And to suggest that the influence solely becomes from one thing, I think it's moved beyond being objective, and I think that we need to rein it back into so. And when we talk about this in particular to, perceived or real, I mean, the reality is, and I think that's what we have to stick with, is that these tensions do exist. And I'm not sure, with even the suggestions that you've laid out, if it solves the very narratives and the anecdotal instances that you suggested. So say that the executive branch gets an appointment to Judicial Merit Selection Commission. There's nothing to prevent that same court case scenario that you suggested from happening again. It's just as likely to happen after believing you get appointments from the executive committee as it did before. So to conflate the two and say that this is a direct cause or this is a direct impact to that, I don't know if it's fair. I definitely don't believe it's objective, and that is my concern. And, let me say this. I believe in separation of powers. I am for checks and balances. I have no issue with executive appointment on the JMSC. What it comes back to me about, though, is we know constitutionally this responsibility was given to the legislator. And so with that, even though in statute we can deal with Article 5, Section 21 and how we make it up, I still think that ultimately the legislative body has been prescribed or designated as that branch that has the final say. So I believe in input from stakeholders. I believe in people being at the table. I don't believe you're outside at the glass, face pressed up against it. If you are, it's because you choose to be out there. I think there's an opportunity for input. I think that input can be increased. Did you know? I struggle with the attacks and the narrative that is being, I believe, presented, because I believe it's one-sided. And when I feel as though personally something is being described with exaggeration or hyperbole or excessiveness, I'm not saying that a problem does not exist. But if you have something that is a small percentage of what overall is a judicial system, I don't believe that it calls for the type of drastic measures that I believe have been offered in some of the instances. I mean, I think to remove all lawyer legislators in theory sounds great, but in practice, I think it's improbable, and I think it doesn't make as much sense. And so to suggest that, now I'm even open to the ideal of limiting the lawyer legislators or even having term limits. I'm okay with that because I think that provides balance. But when the conversation moves from being balanced, I believe that it really sets us on a train wreck schedule to create more problems than are already there. Because in my opinion, and this is my final question to you, when we talk about the problems that we have from a percentage standpoint, do you believe it is a majority? Do you believe it is something that happens like over 50% of the time, or do you believe these perceived or probable instances that they are the exception and not the rule, or do you believe that this is common practice in the judicial system of South Carolina, that there is undue influence being exerted? We talked about the high-profile cases, which we believe is a great example, and you referenced the smaller cases that are not public. In the smaller cases and the spaces and the places throughout South Carolina, if you show up in a courtroom, do you believe that the norm is there will be undue influence exerted, or do you believe the norm is individuals will get a fair case? I, in asking that question, answer it myself and saying I don't think there are enough lawyer legislators practicing for it to be the majority of the cases that individuals come into. So I don't want to, and this is me, I don't want to take something that is isolated or, at the worst case, a small percentage of what happens, and to quote Judge Kittredge on last week, let us legislate, let us improve, let us reform based off of what the norm is and not extreme exceptions, because you yourself have said here today that most of the lawyer legislators do not account for
That I have
the small
experience with.
instances. Yes, go.
That I have experience with.
Right.
I'll let other people speak for themselves. I think there was a question in there. Was it about the percentage? I'm not trying to be cute. You asked a question. I want to answer it.
I can restate it if you like.
No, don't. I will say this.
With the same length and detail.
I will say this. I believe the vast majority of the anecdotal stories that we could tell you probably come from a very small minority of practicing attorneys who serve in the General Assembly. The one thing that I didn't want to do is when you come in here, and by the way, a lot of the anecdotes that I've given y'all, I have sanitized to the point to where they really lose their impact, and I've done that to protect identities. But what I can, when you're answering me back a minute ago, you were like, you think it's just kind of, it could have been for other reasons. No, the reasons were clearly stated by the people in the storyline, why the influence was being exerted. And so, and I could give you dozens upon dozens upon dozens of stories, but the last thing I don't want to do is y'all ask for data, and then when we present it to you in anecdotal form, it comes off as an attack. The last thing I want to do is attack anybody on this committee or in this body, the whole General Assembly. I think the vast majority of people in the legislature are honorable people, especially those who practice law. But I'm gonna close with this. Do we believe, this is a rhetorical question, do we believe that all three branches of government should be equal? If that's a rhetorical question, you don't answer me, I'm answering you. I'm gonna answer that, yes. Should we be equal in all respects? Yes. Should we be equal in who serves in the third branch of government? And the answer to that question is yes, for its own sake. Forget the anecdotal, forget the statistical. Should the executive branch have parity of power in the selection of judges so that the people have a direct say who's on the commission? And that is what I'm here today to argue for. And I appreciate the time you've given me.
Well, let me say this. I don't think we're being attacked by the presentation that you have given today, right? And to offer anecdotal stories as, rationale, I don't think is an attack. What I'm saying, hear me clearly, is that I don't think that meets the standard, right? Because even in the story that you told and people say that they said, that they overheard, that this did that, to me, that doesn't meet the standard. And thank you for sanitizing it, that protects whomever or presents whatever. What I'm saying is when we talk about this process and we talk about JMSC and the work that it does, I just think it needs to be a more practical and pragmatic approach to who gets appointed, why they get appointed, what point it is. I think to go into that, to me, is almost kind of like a red herring that's dragged across, the trail of who's trying to investigate or figure out what's going on. Again, I'll say it in closing, I have nothing against, as a matter of fact, I would be a proponent for executive input and having an opportunity to appoint to that commission. But I think, and this is just me, and trying to be very objective about it, because I don't think it has to be personal. I think it's beyond this point in time. This system has been here for a while. It outdates all of us here. I do think it needs to be incremental. To quote Judge Kittredge, I do think we need to make incremental changes, review, see how effective they are, then come back to the table again. When we talk about improvement and making adjustments to our system, I think it's a never-ending task. I just, again, am troubled with that piece of it. And to me, that is the part that I think isn't fair to the conversation, and I don't know if it's productive as well. Thank you.
Ms. Wetmore is recognized.
Thank you, Mr. Chairman. Thank you for being here. We appreciate you, and I appreciate your perspective. Like everyone else, I think we're all here for the same goal. The question is how we get there. So, I tend to agree with you that we could look at different makeups of JMSC, look at term limits, all of these things I think could get us to a better perception. I spent many years practicing law, and on the whole, I think that the judiciary gets it right. But I think to the extent that we are here to solve a problem of public perception, I think making some changes could be a really productive way to do that. What I'm trying to, I guess, sort of tease out or get a better understanding of is who that should be, right? And I think your suggestion that it be the executive branch, I don't know that solves the problem, in my opinion. When I read, Justice Kittredge, when he came last week, provided us with an article about the history of judicial elections in South Carolina, written by Professor Wilcox at the USC Law School, and read it with great interest. And all throughout our history of constitutional jurisprudence, we have always vested the power of judicial elections with the legislative branch. I think, probably started, according to this article, with a reaction to the crown, to England. We had settlers here that were very resistant to the idea of the king appointing the justice. So, it talks about how in all the constitutions, all the language in the 1700s, it was always the General Assembly. And then we get into the 1800s, and we did a major reform, and the debate was between popular election and the legislature, and it remained with the legislature as a compromise. But at no point do I see a discussion or a consideration of that moving to the executive branch. And so I'm wondering, constitutionally speaking, where that idea comes from. Where I don't see support for it anywhere in Article 5. Where is this idea of an executive appointment suggested either by our framers or in anything that we have in front of us?
I think you can extrapolate from the founding of our federal government, our federal constitution, and I'm not advocating for the federal system of electing judges, okay? Don't read into that. But, and Justice Kittredge, who I listened to last week in the car while he was testifying before this body, and I agree with nearly everything he said. But one of the things he said, and I'm paraphrasing him, I don't want to misquote him, but he alluded that the executive should be a partner in this process. And I think it goes back to the idea in Federalist 51, I think it was James Madison, and I'm paraphrasing him, that there should be tensions. Ambition should check ambition. And you have three silos of power. You've got the executive, legislative, judicial, and they should all three have checks on each other. That was a constitutional precept in the founding of our federal nation. And we borrowed a lot of those ideas in our state government. We are required under the U.S. Constitution to have a Republican form of government. It doesn't require the same system as the federal model, but that it be Republican. But one of the ideas, Republican in the sense that republic, the point that I'm making is that we can borrow from the federal system that the ambitions of the legislature and executive should be equally checked by the executive branch, just the way that the ambitions of the legislature and judicial should check the executive branch of government. We should all three have checks on each other. I think when the tension is equal, and there should be tension between us. Right now there's tension. We're having y'all are asking great questions. You're pushing back on me. That's good. That's good tension. But in the application of powers of government, there's not equal tension with the executive branch. And I feel like we're better served when the executive branch is an equal partner. And by the way, you were right, Representative, and the others who spoke were right. You guys have been given the power under the state constitution to elect judges. No one disputes that. No one wants to take that or advocate for that to be taken away. What we're advocating for is the Constitution is silent as to who sits in the vehicle, the JMSC, that participates in that process. And it's silent, and I'm not saying I presume, but I would assume it's silent because there's some empty chairs there in that vehicle for the executive branch to sit in. And in order to have parity of power in this system, I think the executive needs to have a significant number of those seats. If you want to push back and say it shouldn't be all, the legislature wants to have some appointments, that's a position, the orange, remember the orange? My interest is that the executive branch have an equal say in who sits on the bench, because who sits on the bench then gets to turn and check us back every single day. And my office gets told we're wrong, the solicitor's office get rulings against them. We welcome that, we want that, we think that's good government.
So we agree that it's implied, but not anywhere
Yes, ma'am.
stated. Okay. So right now, we have put in place, we did the big reform in the 70s. We've put in place a number of ethical guidelines, and I have some other questions for Solicitor Brackett about this, but we've put in place a number of guidelines already to ensure, sitting members of the General Assembly cannot run. So if we were to give all or most of the seats to the governor's office, would members of his staff be prohibited from running?
That's for this body to have that conversation when you pass a law.
Would his donors be prohibited from running?
Again, those are all policy prescriptions that this body, you guys can put the guardrails in on the executive branch in statute that he will then have to sign. So those are all good questions that need to be addressed, and there needs to be a lot of transparency. There needs to be a lot of restrictions. I mean, term limits. There's a lot of things that we can put in there, that the qualifications for the members, who they are, how long they serve, what they can and can't do politically. All of those are things are fair we would support that.
All right. My last question is sort of asking for your help.
Yes, ma'am.
As we know, South Carolina is traditionally Republican state. Consistently in statewide elections, we see about 55% Republican, about 45% Democrat in statewide elections. Help me explain to constituents, especially Democratic constituents who elect me, why they would have a voice. You talk so much about the accountability. You talk so much about how the governor's accountable to everyone. I think there is a perception, again, maybe it's a problem of perception, but that many of these elections are decided in the primary. Help me explain to my constituents, particularly those who might not vote in Republican primaries, 45% of South Carolinians, in fact, why they would have a voice with the governor in this situation.
Well, my thinking on this is not seen through the party lens, and I know that you have to look at it through the blue versus the red lens, and I understand we all have to look at it that way. I don't want a Republican or Democrat judiciary. I don't want a Republican or Democrat law enforcement. I don't want a Republican or Democrat criminal justice system. I want a criminal justice where a victim who has had their life destroyed by some unspeakable crime committed against them isn't re-victimized by the very system designed to protect them. And like George Washington, I wish parties didn't exist, factions have evolved, and I don't want to design a system of government that's influenced by a party faction. I want to design a system of government where there's a lot of sunlight, so that a Democrat who's governor or a Republican who's governor is afraid to do something that looks partisan because it looks bad. I'm trusting that people, and all of you up here have a political affiliation, and all of you up here have a philosophical viewpoint. But all of you up here don't ever want anyone to say you're not for good government because of your politics. And I believe that the best antiseptic for that is sunlight. Having an open discussion like this, giving the governor the appointments, and you all have the ability to put guardrails on there. And if the governor is putting their appointments on there that aren't representative of the state or aren't representative of the rights of victims or law enforcement who are defending those victims, then that governor can be held accountable. And again, I don't want to go into the partisan lane because I don't think this is a partisan issue. And I've talked to many Republicans and Democrats in this body, and I have seen skepticism from both sides of the aisle, and I have seen total support from both sides of the aisle. And I think whatever you design in your statutory framework for giving the governor that ability to appoint, you can address those political concerns if you want in statute. That would be the only prescription I could think of. But at the end of the day, it's really, for me, it's about how do the victims perceive the criminal justice system? How do the business community see this as a fair state, a good state to do business in? And do the victims feel like they're getting justice? And at the end of the day, that's ultimately what my goal is.
Todd is recognized.
Thank you, Mr. Chairman. General, thank you for being here. Thank you for spending so much time and thoughtfully going over all of the questions and comments that you've been fielding and for your testimony. You know, as you know, not a lawyer, so I might not be as skilled at the dance that I see going on thus far. So I'm probably going to come at you a little more straightforward because here's my concern. You know, I appreciated the analogy, the orange story that you told. The difference that I see between that and this is there was at least an acknowledgement that there was a problem between the two parties in your story. They both wanted the orange. I'm not sure that we have agreement yet, based off of what I have heard, that there is a problem. And if we don't get to that point, I don't know how much thoughtful consideration we can give to a solution. So I'm going to need you to, you know, and whoever comes up afterwards, to unequivocally say, is there a problem? So that we can at least get that out of the way and not dance around that particular issue, so that hopefully we can go to work on trying to find the solutions to either a fix, reform, whatever the terminologies different folks want to use. Now, I get it. I feel it, as I'm sure everyone else in this room feels. There are people that I think are taking this personally. And I get that. As I said, I am not a lawyer legislator, so I cannot understand what my colleagues that are feel like when we have these types of discussions. And I don't want them to feel that way, because I agree with the comments that I have heard that the vast majority of folks currently serving and have served in the past, and I think we've got to talk about that as well. I think the ones that are sitting in the seats now are the ones that are feeling attacked when I would submit that this problem has been going on for some time. This is because I do believe that there's a problem. I don't believe that this is anything new. So this isn't about the ones that are currently on JMSC right now.
Of course.
This is not about any member or colleague of mine that is serving that is a lawyer legislator. And I want to get that out of the way first and foremost as we move forward. To me, it's about, number one, is there a problem? Number two, is there a potential for a problem that currently exists that we need to address? And I believe that the answer to that is certainly yes. And I need not only, and again, so when I ask these questions, they are going to be straightforward. And I'm not asking them just of you, General. I'm asking them of whoever comes up here and testifies as we move forward also. But I really need to get to that. And so, again, in the vein of recently, currently, historically, and in the past, do you believe that undue influence is put on judges by members currently or in the past of JMSC or members of the General Assembly, both the House and the Senate, that may be serving as lawyer legislators?
Yes.
Do you believe that some judges currently or in the past are concerned about retribution by members of the General Assembly that may be lawyer legislators or serve or have served on Judicial Merit Screening Committee?
Yes.
Do you believe that there have been rulings that have been made historically? And this is very pointed, I acknowledge it. Do you believe that there have been rulings or decisions that have been made that would have not otherwise been made except for the fact that a member of JMSC or a member serving in the General Assembly that was also a lawyer on the case was before the judge.
Yes.
Thank you, and I hope that I can get some of those straightforward answers from other folks. Just for any other context, I get it.
I do want to say one thing. I do believe also the inverse is true. I believe that attorneys in the House who serve in the House or Senate have walked into court and got a favorable ruling, and people walked out and said the judge only gave them that ruling because of they're in the House or the Senate. And I don't think that's true either. I think this is as much about protecting those who, there are judges who have ruled in favor of lawyer legislators, and that was the right ruling to make. And there are lawyer legislators who've won cases because they argued the law better and had better facts, and that's true. So it cuts both ways. But I have seen it cut against us, and I have seen the influence, and I've had hundreds of prosecutors and victims see the influence directly with their own eyes. At the same time, this is much about protecting the integrity of the judges. I believe the vast majority of judges, and I think in some ways, I've had judges intimate to me that they hate it when a lawyer legislator walks in and that they're afraid to rule in their favor. Not that they don't, but they're afraid of what people will say. They think about that. And it's not fair to the lawyer legislator who may have a good case. So anyway, I do want to be fair to all parties, the judges, the lawyer legislator, the victim, the prosecutor, and the law enforcement official. It cuts all ways. But yes, I have seen it cut against us because of all the reasons you just said.
And it's not just about y'all. I mean,
No.
that's what I'm saying. I hate that it seems to be, prosecution versus defense or whatever terminology you want to use. Because I'll say this, I've had lawyer legislators that I have served with, maybe not now, but in the past, that have agreed that there exists a problem and it needs to be addressed. Now, guess what? Don't want to come forward. There is a loyalty situation. It exists. I get it. We're human, okay? A lot of folks don't want to step out against those who are in the profession with them for whatever reason. But it has happened. And there are members that have served or are serving that are a member of the bar that believe that changes need to be made, whether they are on legislation or they are not. Here's what I want to get at. I want to go back. It's a totally different scenario, but it continues to pop into my brain. I agree with Representative Caskey. Could not agree with him more. I am just as concerned about, you named the law firm in the state of South Carolina. I am just as concerned about one of their lawyers serving on JMSC as I am a member of the General Assembly that's a lawyer legislator serving on JMSC. I think that he is absolutely right that the allowance of undue influence would exist regardless because they have something to gain. There is an opportunity to benefit by that person sitting on that clearly very important panel of screening. So, here's something that continues to come up. It hasn't necessarily been said, but I have picked up on it. Only lawyers can serve on JMSC because they are somehow more equipped to make a determination on the qualifications of these candidates than anyone else. And I have, to this point, accepted that. But as I've sat here and listened to the line of questioning, if that was the case, I, as a member of the General Assembly who is not a lawyer, perhaps shouldn't be able to cast a vote for these judges. So I have learned so much about the process over the course of the last 2 weeks. The Citizens Advisory Committees, all of these folks that do so much work on the front end and through the process of the JMSC screening qualification process, do you believe that only lawyers are able to serve and then make those decisions on qualifications for candidates for judge?
I do not believe that it should be left only to lawyers who serve in the legislature to do that. However, every major governing professional board, medical board, dental board, is going to have members from the profession serving on it. I certainly don't want to see a system where the lawyer is cut off of it but I don't think you should be discriminated because you don't have a law degree, that you don't have something valid to offer. We have people who've spent their whole lives committed to victims, right? Serving victims of crimes. I think they should have a voice.
But I'm correct, and lots of lawyers are participating in the screening process, just not the vote. And that's what we're getting down to. Who's coming out of the JMSC process and who's not? And who's coming out with a certain classification attached to their candidacy that others are not. And I'm simply asking, do you need to be a lawyer to be able to make that determination after, or can someone?
On qualification.
Yeah.
I think the opinion of an educated person, regardless of whether they have a law degree, if you give someone clear metrics, if it's in the law, that this is what you have to have in order to be an effective attorney, then a non-lawyer can certainly read those metrics and say, yes, you are qualified. And then that person gets a chance to go sell themselves to the General Assembly.
And they certainly can do that with all of the work that is going on the front end throughout that process, correct?
Absolutely.
And so then, if that's the case, if we have a JMSC where the members who are casting the votes and making those determinations have no benefit that they are able to gain in that process, they have no benefit. They're not going to be appearing before ultimately who the victor becomes, because they're not lawyers, right? Would that not then obviously send a very clear message to the public that we are taking this serious and that we are trying to remove not only the perception or the appearance that someone can game the system for themselves, but we are doing it. Like, it's not a perception. We are clearly saying that here is a system by which the most important step in the process, arguably, and I do believe that is the most important step, who comes out of that screening process with certain designations attached to them, that's the big step. Then I believe that we come up with a solution to what I believe is the current problem.
Representative,
Would you agree?
I see where you're going. I would say this, just like a minute ago I said, I don't want to discriminate against someone because they don't have a law degree. I don't want to discriminate against someone because they do have a law degree. And so, this is, obviously that would address, but there may be other ways to address that.
Yeah, well,
And so, I would ask this body to not look at someone and say, because you're a lawyer, you shouldn't be able to vote or be able to screen who gets to go to the General Assembly. Because you're not a lawyer, you don't get to. I don't want to discriminate against anyone because of the profession they've chosen. You could have a really good, we've had this conversation with magistrates. We've got magistrates who don't have law degrees, and they're some of the best magistrates, right? So I don't want to say, because you do or don't have a degree, that you should be disqualified from serving on the JMSC. I don't want to nail that position down. I'm here for my interest to get the executive branch at the table. So I know where you're going. I just don't want to go that far.
thank you.
Yes, sir.
Thank you, Mr. Chairman.
I will observe, I think there's going to be a balance, Mr. Ott, wherever we put it, and term limits may play some point too. Say, for example, if I served, but then I wasn't going to be here when you came back for re-election, then I could go practice. That seems like a small thing, and of course, they've got 4-year terms, but we don't have term limits in the statute. So just another idea. Mr. Bamberg's recognized.
Thank you, Mr. Chair. Attorney General, thank you for being here. I do have a really pointed question to ask you, and I'm going to ask everybody who comes to the podium the same thing. What judges in our state that are on the bench do not deserve to be on the bench?
That is a question I'm not going to answer.
And I anticipated that. Okay?
Because, and let me qualify it. To be able to get the stories, to be able to tell the anecdotes or the stories of people who heard or saw things in real time, and to talk to prosecutors around the state, the one thing that was put on me is, please don't identify who I am. Please don't identify who the judge is, because we all have to appear in front of him. Please. And so it's difficult to tell these stories in a R-rated fashion, because the last thing you want to do is invite retribution or perceived retribution on people who trusted you with their stories. So that's why I wasn't trying to be antagonistic, Representative. I just trying to be protective of the people, and I know you understand that,
No,
so thank you.
I do understand that point. But I will, and again, I'm gonna ask everybody who comes up here today the same question, okay? And I've already seen in some of the information submitted, that it's not gonna get answered. The judicial system in our state appears to be under attack, okay? And the difficulty that I am having, and myself, everybody up here, I think, is very committed to trying to improve the process, right? Anything created by man is subject to being improved. It's not perfect. I understand that. But we see these stories about individual criminal cases, okay? So the Price case and this and that. But I have not heard a single name of a judge. It's JMSC has these problems. Lawyer legislators don't need to be on JMSC. We need to do this. Maybe we need prosecutors. Maybe we need members of the bar. What judges are the problem, right? And I do understand this idea of, well, worrying about retribution, et cetera. But if the conduct of the judges is so bad, such that the Senate, the House, the Post and Courier, all these news stations, we've got letters coming from solicitors. If the conduct is so bad from any individual judge, there's something that could be done about it, right? How do you make sure maybe they come up for screening and don't get screened out? Well, somebody's got to say something. So if we're here talking about altering the entire way our state selects judges, which is a very big deal, it has not been done that many times historically. If it rises to that level, my problem is, why will no one identify somebody, right? We tell law enforcement sitting out there, myself included, as a House member back home in a small community, what do I tell my community? If you see somebody get murdered, don't play the no snitch game, say something. Go talk to law enforcement. I tell people and SLED agents that all the time back home in Bamberg, and I tell the community, if you see something going on, you need to say something, report it to the police. I'm not a cop, right? But all I hear is a bunch of, respectfully, right, and again, this is not directed to you, the process we're going through. A lot of information criticizing JMSC, and I'm not knocking anybody for how they feel about it, okay, or what they think about it, but the criticism of JMSC, the complaints about lawyer legislators getting certain things in court or whatever the case may be, somebody's got to answer the question of who the problem judges are so that can be looked at and addressed as a part of the process.
May I?
Yeah, of course.
Representative Bamberg, sometimes the judges are the victims. And you were presuming that it was always the prosecutor who didn't want their name mentioned because the judge was going to have retribution against them, but it's the judge who fears retribution and has been told by other judges, you will lose your job if you don't do X. And so it's difficult to appear in front of these men and women who trust us to tell us these stories and these viewpoints. This is about as much about protecting those on the bench as it is about protecting men and women in front of the bench. And it's also about protecting the lawyer legislators who aren't doing this, who aren't abusing the system. You're getting a bad rap. So we're all victims. And so it's hard to out somebody when you can cost several people their jobs.
What judge it has been threatened, or what judge, who, right? And there has to be a person attached to it, right? Everyone involved in the process has an interest. I think it would be very disingenuous to represent to the public as though everybody who is stepping up and asking for whatever their ask is as far as tweaks to the process does not have a vested interest in some aspect of the process, okay? And I'm not saying that's a bad thing, okay? But right now, it's a bunch of groups interested in what they want with phantom problems, right? Everyone, it's hey, I have a problem. Well, what is the problem? Well, such and such and such and such. Okay, well, where's the proof? You know, that is the problem that I'm having, is that some of the stuff being said is very bad stuff. These are not small allegations to levy against either the judicial branch of government. You know, I really wonder if some of the public concern stems from one-sided representations about what the problems are, but no one can no one is, other than individual legislators that people have a problem with, no one can identify any other parties in the judicial branch who is afraid. Who? Are you aware of who is afraid? What judges are you aware of that are afraid?
I am aware that people don't come forward because they don't want to lose their job as a judge, or they don't want sometimes it's the judge who's the victim, sometimes it's the prosecutor who sees the judge and the lawyer legislator doing something that they perceive as inappropriate. Sometimes it's other parties, but the point is that if you come out and you identify, again, all of these examples I have here are I was promised that I would not identify the jurisdiction, the judge, or the individuals involved, but that I would sanitize it so that it couldn't be termed, because they don't want retribution. Now, some of my colleagues might be able to speak for themselves, and they might be able to give you direct, and I presume they will. But, you know, we've heard jail calls where inmates in jail say, yeah, my lawyer says they got influence over the judge so they can get this thing resolved. I mean, we hear these things, and whether the judge did anything wrong is, I'm not saying that. That's what people believe, and we're trying to address that perception.
So we're supposed to change the entire judicial system in this state because of a couple of jail phone calls of someone saying, my lawyer said, or someone said. That is the problem.
That's not what we're asking, Representative.
Let me ask this. In this state, there are 16 prosecutorial circuits, right? 16, and they're elected by the public in their circuit, right? Are prosecutors a part of the judicial system in our state?
Yes.
All right. Who controls prosecutorial dockets in our state?
The courts.
The courts do? Who calls the cases?
The prosecutor.
The prosecutor.
Working with the court.
Okay. Do you remember a few years back, and this matter was before the Criminal Law Subcommittee, a few years back, there was legislation regarding, and I'll tell you why I ask you this. There was legislation regarding taking that power from prosecutors, the ability to effectively control the criminal docket in this state, and putting it with the courts, like it is in common pleas, right? You know, in common pleas, the courts control the docket, right? Mm-hmm. Do you remember any discussions about that, or what the prosecutor's stances were with regards to the judges possibly taking over their dockets in criminal court?
Yes.
All right. And they were against that, were
Yes.
they not? They
Yes.
were. As a part of this process of judicial review, basically, all right, what changes can we make? Obviously, we're looking at JMSC. Obviously, there's discussion about magistrate level, right? Are the prosecutors in our state okay with a part of that review also entailing whether or not their ability to control the criminal dockets go to the court? I mean, if we're going to fix JMSC, that should dead the concerns about the fairness of judges, right? So why can't you can't speak for them. I'm going to ask them the same question. From the Attorney General's standpoint, would the Attorney General's office have any problem with the courts being the ones that call criminal cases like they do in the civil context?
The courts have already spoken on this issue, and we don't agree with it, but we're abiding by it. And something you said a minute ago, Representative, I just want to make sure you're abundantly clear. We're not trying to overhaul the judicial system. We're simply asking for a seat at the table to the selection of judges. That's not overhauling the judicial system. Giving the executive branch of government a seat at the table. an equal seat, an equal player, a partner with all of you as it relates to selecting judges. You get to vote on the judges, but let us have an equal seat at the selection and qualification process. Is it gonna cure everything? Of course not. But it certainly gives us a seat at the table, which is what we want.
I understand. And I'm not knocking anybody, right? This is part of the process, right? Everybody has input. But I need to know, the Attorney General's office is the chief prosecutorial office for the state, right? Just like the U.S. Attorney's office is the chief for the feds in the state. Would you see a problem with the courts taking over? And I'm sure at some point someone's going to speak to the backlog of pending and open criminal cases in the state of South, and it is a ton of them, right? But there are a lot of crimes that committed, okay? So it is what it is. But should the courts take that control? How does it work right now, right? A solicitor goes and they say, all right, here are our open cases, and we want to call this one for trial. Or, hey, we want to do this on this one, right? And the judges accommodate the prosecutors, right? That's generally what happens. The judges do accommodate the prosecutors in what they choose to do, correct? So are the prosecutors in our state, as a part of this process, okay if at the end of the process and recommendations are made, one of the recommendations is that the prosecutors no longer get to unilaterally control the criminal dockets in this state?
They don't unilaterally control them now.
All right, and I get you saying that.
The court's already ruled on this. I'm not trying to be difficult. And Representative, if I can, and look, I am happy to stand up here as long as this body wants. You have oversight over me, and you're asking great questions, and I will be here as long as you want me to be, but I also feel like there's a lot of people sitting behind me who are going to testify probably as long, and y'all are doing a hard break at 2:30. I'll come back. I'll come to your office. I don't want to monopolize the entire hearing. I will monopolize if you keep me up here, but I also don't want to take away, because they have a lot of thoughts on this too. And I'm here not to represent them, because you're going to get a bite at the apple with these solicitors and the sheriffs and the chief. So anyway, I only say that to say, I'll come back to another meeting and I'll stand up here and take fire on the docket management, and we'll do that if that's what you want. I just don't want to monopolize and take away their time.
I'm trying to give you as much airtime today. You look great.
And you look great too.
But let me ask you this one last thing. And to my committee members, I do apologize. All right, so we've seen a lot of mention of crimes and a lot of talk about victims, okay, and about how this impacts them, et cetera. All right, in our state, would you agree that when the alleged perpetrator is a member of law enforcement and it involves someone's civil rights violations, right? That happens in this state, right? Mm-hmm. Unfortunately, sometimes that happens. And the prosecutors control that review, right? Why is there nothing in anybody's letter about the fact that there are innocent victims that are citizens in the state with constitutional rights? Right? Bryant Hayward in Charleston, 4 years, that young man who was rendered a quadriplegic, for 4 years, he waited on a decision to be made as to whether or not the individual that shot him in the neck would just be indicted or freed for 4 years. Your office actually had to take not only that case from a solicitor's office, but a number of other cases. I would be interested as a part of this process this is for everybody watching. If groups are going to make presentations, please don't make them so one-sided. Because if you want credibility, there are members, myself and others, that really want to listen to legitimate concerns. Not self-interested concerns about, we don't like decisions that were made. Everybody's a prosecutor. I hadn't seen no judge get indicted. I hadn't seen none of that stuff. Raise legitimate concerns, but I am seeing a bunch of stuff that is so one-sided. If you're going to talk about victims, talk about all victims, right? who can these citizens go to? We talk about people not feeling like they have a fair shake if it's a lawyer legislator in court, or the judges are worried, or the prosecutor feels like something, et cetera. Who do people go to when it's the solicitor's office that's the problem with the judicial process? What citizen should have to wait 4 or 5 years to find out if the government is going to defend them?
Well, and again, I don't want to go down a rabbit hole, so I'm going to not go down a rabbit hole for time's sake. But there's always a side of the story that doesn't get told as to why a prosecutor does or does not do something. Sometimes it's because they can't get certain lawyers into court for years. And I'm sure some up here may testify to that. But if there is a specific case that we have been involved in, and you're saying we took a case that wasn't getting tried, I'm happy, and I have 8,000 cases right now on my docket. I'm happy to sit down with you and or the solicitor to have a conversation to give you the answer. Because if we owe you an answer, if it's an ongoing case, it may be limited, but if I can give you the answer to your questions on those cases, I will.
And I'll clarify, the delay, I'm not talking about the Attorney General's office.
Okay.
I'm talking about when SLED finishes and the solicitor's office is the one that gets to make the call. Do we indict? Do we not indict? Do we present it to a grand jury? Do we not? And a citizen who's been victimized, unfortunately, right, has to wait so long. This is again, there are a lot of problems. We talk about, because we're looking at the judicial process here, the selecting of judges, how can we improve things? I just think it would be way more credible if when folks submitted information, it wasn't so one-sided and only about the things they don't like, while not actually mentioning any of the other problems that the institution of prosecutorial bodies in this state are contributing to, that fall in line with the same thing they're complaining about other people about. That is all I'm saying. And thank you so much for,
Thank you, General.
for all your time.
Thank
Mr. Bamberg, a couple observations. One, I think the Attorney General was referring to Langford, which I think was like 2012. That's when the Supreme Court said the judges do call the cases. So the bill I think you're referring to was mine, where I was trying to get it back for the solicitors to call the cases that, but anyway, so right now there's hybrids in most circuits. But fortunately for all of us, we're going to get to hear from the solicitors now, so you can ask them about all kind of things. Ladies and gentlemen, you heard we had a hard stop at 2:30 in classic legislative time. We're going to make that hard stop 3. I want to be respectful to everyone who's here. General, we want to thank you for your time. You're welcome to remain with us. We're going to take our 10-minute break, and then my intention is to hear from the solicitors. If Professor Fitzpatrick is still available when we get through hearing from the solicitors, we'll take him. Anything after that, starting with Hugh and Chief and the sheriffs, I just want to be respectful of your time. That it looks like that's gonna, you saw this took 2 hours with one witness, so, because I don't want to shut down anybody's ability to ask questions or you guys to provide a good response. So if any of you guys that are later down, I know we got Judge Dash too, any of you, the chiefs, anybody that needs to leave, if you'll just let staff know, our intention's gonna be the week after Thanksgiving. I think what we'll do, we were talking about an afternoon hearing so citizens could get off work and participate. What we'll do, and of course we had defense bar members request to speak. I think we'll shoot to having a full day that day, probably start in the morning, maybe take up where we have our agenda now, and then and fill in with the citizens in that afternoon. So that's the best I can do for you right now, but I didn't want you stuck here and suddenly us stopping and you still sitting in the audience. So feel free, and if something happens, you feel the need to leave, we can certainly put you on the agenda next time. I'm really looking at the folks that I don't know that, I'll be surprised if we're fortunate, we'll get the solicitors and Mr. Fitzpatrick if he's willing to wait with us. But staff, if you'll check with the professor, see if he can do that. And then I think when we come back, let's come back at, I know how the legislature is, let's come back at 12:30. And we'll start with Solicitor Pasco, then we're gonna have Solicitor Brackett. We're gonna go together without questions from those two until they finish, and then we'll ask questions. Thank you. page now. Yeah, I keep missing, there we go. I want to see what I learned about Mr. Pasco. So we've got two solicitors next. Tried to do it while everybody's still in the bathroom so we could get on out of here sometime today. Next with us, two solicitors, which will present jointly to some degree. David Pasco is Solicitor of First Judicial Circuit, which is comprised of Orangeburg, Calhoun, and Dorchester counties. He received his undergraduate degree from Citadel and his law degree from the University of South Carolina School of Law. Kevin Brackett is the Solicitor of the 16th Judicial Circuit, which comprises York and Union counties. His legal career has been entirely devoted to prosecution. He received his bachelor's degree from the University of South Carolina and his graduate is a graduate of the University of South Carolina School of Law. Gentlemen, we welcome. I did tease you guys. I've been watching your face for the last 2 hours, and for the rest of the solicitors, they look like bailiffs. You know, and you know how the bailiffs enjoy our trials sometimes during the dull part. So I think Mr. Pasco is going to go first.
Good afternoon, Mr. Chairman.
Yes, sir. Hold on one second.
There we go. Good afternoon, Mr. Chairman. I'm honored to be here. I am the solicitor for the First Judicial Circuit, which is Calhoun, Orangeburg, and Dorchester counties, home of 3 of the finest legislators who just happen to be my constituents and can vote for me, Representative Cobb Hunter, Russell Lott, and Representative Robbie Robbins, none of whom I babysat either, I will add, in the past. I've been a prosecutor for 30 years now. I've tried hundreds of cases in front of magistrates, family court judges, and circuit court judges. I've argued cases in the Supreme Court. And I mentioned these trials, but I've also pled, had hearings, and appearances in thousands of cases during my 30 years as a prosecutor. And I tell you all that because I estimate that I've been in front of anywhere to as many as 100 different judges in the state of South Carolina in the last 30 years. Over 100. So take it from me when I tell you this, someone who's appeared before maybe about 100 different judges. We have good judges in the state of South Carolina. Some phenomenal public servants. You heard from a good one last week in Justice Kittredge. And I hope I'm not screwing up his vote in the next couple of months, but you heard from a great one in Justice Kittredge. Like any profession, we have some good judges, we have some bad ones, but the good far outweighs the bad. So I'm not here to bash the judiciary. I'm here asking to provide them a system where they don't have to look over their shoulders every time they make a decision to make sure that they're not offending a lawyer legislator or a member of the JMSC. I'm also not here to castigate lawyer legislators. We have some phenomenal lawyer legislators who serve us every single day in the legislature. Many of them on this panel right here today, on this committee. Some who've been my mentor for over 30 years, and others who I've butted heads with for 25 years, who I go to for advice often, because we have some great lawyer legislators in Columbia, and I appreciate that. The reason I'm here is because you can help us make the system better. Understanding that it's never going to be perfect, you can help us make the system better. I have had many judges, plural judges, in the last 2 years as I've gone around the state talking about this issue, judicial reform, call and tell me, and this is a verbatim quote from one of them, any judge who tells you they don't worry about offending a JMSC member in their courtroom is lying to you. That's that judge's quote. I wasn't going to mention this, but Representative Bamberg got me kind of fired up. I had one judge call me recently, within the last 18 months, I believe, just to vent, almost in tears, to tell me he was forced to give a JMSC member a continuance in a civil case, wasn't even criminal, in a civil case, because he feared that if he didn't, he was going to lose his job when he had to go up in front of the JMSC just weeks later. And if you don't think that happens, hold tight and just wait and see what Solicitor Brackett and I have to talk to you about today. We solicitors hear it from the judges and the bar. They don't like the current system, but they're not going to stand up in front of you and tell you that when they have to go testify in front of the JMSC. With all due respect, Justice Kittredge, who I have incredible respect for. I was cutting my teeth as a prosecutor trying cases in front of him 25 years ago when he was a judge. He's still one of my favorite trial judges. But he got up here, and there was an editorial this weekend about that in the Post and Courier. The optics of him having to come up here and testify about the system. The same day or the day after, he has to go in front of the JMSC and ask for his promotion. As the editorial pointed out, the optics are bad. They're horrible. And Justice Kittredge, with all due respect, I've known him for 30 years. His DNA makeup, he's not capable of doing anything but telling the truth. Let me start with that. I know him, but he's got blind spots. He's got blind spots. And I'm going to talk about those. He's honest, but he's got blind spots. In a few minutes, Representative Caskey, I'm going to discuss that fidelity of facts that you called for so eloquently last week. That fidelity of facts, proving that the perception of our current system in the eyes of the public, and even those in the judicial system, is that it's not fair. It's not fair. Trust has withered away, and you can help by taking steps to rebuild it. I agree with Governor McMaster when he said that the public is losing its confidence in the way we pick our judges. I also, like Justice Kittredge, have spoken across the state about issues involving the justice system and judicial reform. And I can tell you, everywhere I go, whether it's the Rotary in Dorchester, Representative Robbins, the Rotary in Calhoun, Representative Ott, whether it's the conservative voices of Horry County, the Republican Party of Greenville County, or the Democratic Party of Orangeburg, everyone I talk to wants change in our system because they've lost confidence in the way we select our judges. The optics of our system are horrible, which is why the only people that I ever seem to hear defend the current JMSC process are the members of the JMSC and friends of the JMSC. But Representative Whitmore, when I go to Democratic Party functions, and I want to go with you to Charleston, bring me down there. Let's talk about judicial reform. Everywhere I go, Democrats and Republicans, 100% know we need to change the way we pick judges, and we need to change the makeup of the JMSC. Representative Wooten was so right last week. This is not a partisan issue at all. That's why Republican and Democratic voters across the state are ready for change. At least that's my experience when I talk to them. Last week, Justice Kittredge said he was intentionally not going to talk about lawyer legislators getting preferential treatment. But then he said they don't get preferential treatment. He specifically cited two high-profile cases as proof. The first one was Gerard Price, where the Supreme Court did rule against a lawyer legislator in a 3-2 opinion. And then the second case he talked about was Murdaugh, the Murdaugh trial, where he said, quote, ask Senator Harpootlian if lawyer legislators get preferential treatment. I want to talk about those two things briefly. Okay, so in high-profile cases, when the world is watching, we can count on no preferential treatment and no one being pressured into preferential treatment. But what happens when the world's not watching? What happens when the world's not watching? Well, we know the answer of that from one of the cases that Justice Kittredge cited, Gerard Price. Because when the world wasn't watching, a JMSC member goes back in chambers with the judge and the solicitor, Representative Mike, and I think it was you that brought that out. I'm glad you did. And the solicitor. But it's the JMSC member who tells the judge what he wants the convicted, dangerous murderer sentence to be reduced to. And the judge does exactly what the JMSC member did with regards to the sentence. And that came out during the Supreme Court hearings. I couldn't believe it. One of the justices asked, well, where did the judge get the idea on that sentence? And the JMSC member said, I told him to give him 18 years. And the judge then signs a secret, unlawful order. That's what happens sometimes with JMSC members when the world is not watching. And as for Senator Harpootlian, whether lawyer legislators get preferential treatment, it has been alleged that I am friends with Senator Harpootlian. And I'm not going to address that allegation at this time. But I will say that I went ahead and called him right after that. And I asked him that question, and I invite y'all to ask him the question. Anyway, you can invite him. But I'm going to tell you what he told me with a lot more tact and a lot fewer curse words. He said, yes, lawyer legislators get preferential treatment. It's not a secret. It's not a secret, which is why he, a Democrat, Representative Wooten, a Democrat, is about to pre-file legislation with a Republican. I saw him earlier. Maybe he might have ran out of here when I mentioned Harpootlian's name, but with Senator Wes Clymer in the Senate, a Republican and a Democrat sponsoring legislation together in the Senate to take lawyer legislators off of the JMSC. Everyone in the system knows about the preferential treatment, whether they want to admit it or not. Representative Caskey last week, and you are someone, I'm not picking on you because you are someone whose background I respect immensely, despite who your babysitter was. You grew up fine despite that. But you expressed frustration last week that the bar needs to defend the system better. But I submit the everyday hardworking lawyers that go to court across this state every day, they see it. They see the preferential treatment. Whether it's the public defender who sees the lawyer legislator getting their client a bond for violent charges that public defender knows they could never get, or whether it's that civil attorney who gets to their docket meeting early because the judge says we're going to go in order of arrival, just to have the judge let lawyer legislators skip the line and go first, even when you guys aren't in session. And even when it's not even the lawyer legislator who shows up for the civil docket, but one of their assistants from their office. It's preferential treatment that goes on every day in our courts because of our current system, which, by the way, now I'm going to geek out on y'all in a little bit. It runs totally contrary to Madison's suggestions in Federalist Papers 51 that Justice Kittredge cited. Before I forget here. The danger of this treatment, though, the most important part of what I'm going to talk about is that the dangers of this treatment is that it erodes confidence in what is supposed to be a fair system for everyone. Before I begin talking about specific examples, because unfortunately, Representative Ott, I do not want to be here. I don't want to talk about these specific examples. They don't make me feel warm and fuzzy at all. They make me feel very uncomfortable, but I'm going to give you some specific examples in a minute. But before I do that, I want to talk or touch on something that Representative Newton hit the nail on the head about in your opening remarks last week, sir. We have to have 3 separate independent branches of government. The perception, if not the reality, the perception is that we do not have that in South Carolina. Our judges, and the way we select our judges, runs totally afoul, totally contrary with Madison's Federalist 51 cited last week. And there's some of Madison's Federalist Papers 51. An independent judiciary is crucial to our republic and the separation of powers, but a judiciary cannot be independent when they are hired, fired, and solely funded by another branch of government. It's just common sense. Representative Robbins, you actually mentioned this to me many years ago, probably over a decade ago. You can't stand the term judicial department. It's the judicial branch of government. Over a decade ago, you told me about how they needed to be independently funded and needed to be treated as an independent branch of government. Under this system, the one we have, the judiciary arguably becomes an employee of the legislature, not a co-equal branch of government. And it's especially unfair when lawyer legislators who hire, fire, and fund these judges practice law in front of those same judges. So I was very pleased when Justice Kittredge mentioned Madison's Federalist Papers 51, because I haven't read it in years, and it gave me the opportunity to pull it up and read it, knowing full well that Madison would not approve of the way South Carolina picks its judges. Madison says we need to have 3 separate independent branches, and that, quote, the members of each should be as little dependent as possible on those of the others, of those other branches. He goes on to specifically say about judges, they are, quote, if they're not independent of the legislature in this particular, their independence in every other would be merely nominal. Madison would not approve of how South Carolina picks its judges. In fact, it was after reading that again last week that when I realized why we are only one of 2 states who pick judges this way. Because the other 48 states know that you can't pick judges that way because it's a total affront to how our founding fathers in Madison said we should pick judges. Now, that's your history lesson today. That's Representative Newton's fault and Justice Kittredge's. But let me also be clear about this, Representative Thigpen. We're not here asking for drastic change today. We're not asking for drastic change in our process. We're just asking for common sense, easy statutory changes that will help maybe restore confidence in the system that we have today. We're asking that you remove legislators and legislative control from the JMSC. Change the way the legislature votes. That's it. We're not asking that legislators not elect judges anymore. We're just asking that you remove legislators from the JMSC. This is not drastic change. It's not drastic change. Right now, I'm going to talk to you about some specific, and I try to keep them almost all fairly recent. I didn't want to go back decades. Instances of preferential treatment, and in my opinion, bad JMSC actions. I know, I'm not going to hold back. Rotten JMSC actions. You're going to hear some rotten actions done by the JMSC prior to you getting there, Representative Caskey. But I want to reiterate that I'm not alleging anything unlawful, nor am I wanting or trying to prove that any of these things I'm going to discuss are a crime or that I would try to prove they're a crime because they're part of our system. But what I can prove to you beyond any doubt, not just a reasonable doubt, but beyond any doubt, is that in these instances I'm going to discuss with you, they do undermine the public and the bar's confidence in our justice system. And sometimes, unless you press for it, I will not mention the judge or the legislator involved unless you press for it. Although oftentimes I will be mentioning the lawyer, legislator, and the judge because I have to. But there is one instance where I will not share the name of the lawyer, legislator, or judge merely because we just found out about this, the solicitor, not 10 days ago, and we're seeking ethics advice on whether to file a complaint or not. All right, let's get started. Let's talk about the most obvious form of preferential treatment that lawyer legislators get, which is protection from going to court. For you non-lawyer legislators who have to go to work when you're not in session, our court that has to go before a JMSC, that has to be elected by legislators and who gets their funding from the legislature, currently gives lawyer legislators 7 months of absolute protection from court. From January 1st through July 31st, no one can order a lawyer legislator into court. And after July 31st, if that legislator's in session, like Representative Robbins is now, obviously he has protection and obviously he needs that protection. So from January 1 through July 31, with rare exception, lawyer legislators cannot come to court. And I am not saying that lawyer legislators should not get protection. They absolutely should get protection. I'm just saying that when it's to that extreme, it leads to abuse. And we're going to talk about those abuses in a minute. Back in January of 2002 on a Thursday, I talked about the abuses this protection creates and the horrible optics of it. How a defendant and how defendants know how to play the game in the system. I talked about how my office had a CDV hand, a criminal domestic violence of a high and aggravated nature case, ready for trial, witnesses ready to go. But on the eve of trial, defense counsel co-counseled a lawyer legislator, and the judge was forced to grant a continuance. She had no choice, didn't want to grant a continuance, but had to. That's preferential treatment for a defendant and for the lawyer. Around the same time, Solicitor Wilson's office had a very serious felony DUI set for trial for January. It had been set for months. It had been set for a while with the victim's family members coming in from across the country to attend. But 2 or 3 weeks before that trial date in January, 2 or 3 weeks before that January trial date, lead defense counsel announces, no, we aren't going to trial. The judge didn't grant the continuance. Who's supposed to control the docket, Representative Bamberg, The attorney did, because the attorney said, I have assigned a lawyer legislator for my office, and he's protected through July. The case had been pending for nearly 3 years when the lawyer legislator was assigned to that case on the eve of trial. 3 years. The head of the firm, a renowned criminal defense attorney, then announced that he was assigning all of his criminal cases to the lawyer legislator. So he told the judge and the lawyer legislator, all of our cases are continued until after July the 31st. And Judge Jefferson, a judge I have incredible respect for and have known for years, had no choice but to continue the cases. But there's another backstory to these cases which shows you that Judge Jefferson did get the last word in doing the right thing, that there are judges who always stand up to lawyer legislators. After the legislator's protection ended, the defense attorney's client was then, of course, miraculously about to plea. They were going to go ahead and plead guilty and take the state's plea deal. And actually, they didn't take the state's plea deal. And if you look in emails, let me get ahead of myself. State versus Thomas Garris. It's all public record, and I'm not going to go over the entire case with you. Guys are more than welcome to look this case up or get your staffers to. There are actually emails where the defense attorney and the lawyer legislator say, hey, we can get our friend Bentley Price, Judge Bentley Price, will take the plea. Judge Jefferson said, no, it's not going to go in front of Bentley Price. It's going to go in front of another judge. And the case pled in front of another judge, and it has already turned into a little bit of a mess. And one of the reasons for that mess, I'll just tell you, is because of the lawyer legislator's involvement. And again, I would invite you, read the emails, read the text messages that are part of the record, and how promises were made to the defendant because they could get a better sentence from the judge because the lawyer legislator supported that judge and got them elected. Another matter I spoke about in the past concerning abuse of lawyer legislator protection involved a defendant out on bond for robbery, rearrested for drugs in December. Their bond revocation was going to be heard in January. The defendant hires a lawyer legislator, and the lawyer legislator says, you can't call my client's case in January now for that bond revocation. Criminal defendants know how to play the system if they have the money to hire a lawyer legislator. And again, honestly, I don't see how anyone can say, and that's why Harpootlian said it with certain words, yes, lawyer legislators get preferential treatment. Let's not deny that. This is the Chief Justice's, let me make sure, order. So after I complained about lawyer legislator protection on Thursday in January, it was reported on Friday. Lo and behold, on Tuesday, the Chief Justice sent out another order, Chief Justice Beatty, saying, lawyer legislators, you no longer get full protection. You are now going to have to come to court for cases that are over 3 years old. The trial judge can call your cases for court if they're over 3 years old. I was extremely pleased with Chief Justice Beatty for doing that. Whether it was because I was complaining about it or not, he made the decision. The next day, I called a state senator and we discussed it. This would have been on Wednesday. And he commended it. But the senator said, we'll see how long this lasts. We'll see how long that order lasts that was signed on January the 11th, telling lawyer legislators they had to come to court for old cases. Because that state senator had run into a Ways and Means lawyer legislator, not the chairman at the time or now, but they had run into a Ways and Means lawyer legislator, and they were complaining a lot about Chief Justice Beatty. And I remember telling that senator, tough, it's an order now. That legislator's just going to have to live with it. So my office was putting together bond revocations and old trials, 3 years or older, with lawyer legislators on the docket when the judge calls me and says, Solicitor Pasco, we can't put these lawyer legislator cases on the docket anymore. And I asked, what are you talking about? Chief Justice Beatty just signed an order about this. And the judge said, well, on the very next day, on January the 12th, the same day that legislator on Ways and Means complained to the state senator about the order, the Chief Justice had Court Administration send out an email saying, ignore my order. The very next day. Now, I can't tell you why he rescinded the order in just 24 hours, but I can tell you what my perception was. And I can tell you what the perception of that state senator was when I talked to that senator later. I don't think I have to say it out loud, because it's also the perception the judges and members of the bar had as to why that protection was rescinded 24 hours later. And Representative Bamberg, who controls the docket in the state? The courts. The chief administrative judge of civil and criminal courts are ultimately in charge of the order of the cases in South Carolina. It was Langford where our Supreme Court said that we cannot let another branch of government control the docket because of separation of powers. That's the judicial branch's role, Representative Bamberg, and I agreed with that. Guess what? I'm the one who did the oral argument, or part of the oral argument in Langford, and I agreed with that. Solicitors should never have, and I said this 12 years ago in front of the Supreme Court, last word on any case. The last word, the word that matters, should always belong to the courts. That's the separation of powers. But in South Carolina, the chief administrative judge for the circuit does not control the order of the cases with the lawyer legislator or the calling of the lawyer legislators' cases. And this transcript from State versus Larkin proves that. Representative Stavronakis from Charleston had 3 cases on the docket, but he's protected from the court because the General Assembly was in session, but y'all weren't in session, I guess, that day, and he came to court. And he went in front of a very good judge, Judge Roger Young. And Judge Young tells Representative Stavronakis, we were told that the Larkin bond revocation, which, to let non-lawyers know, that's a risk of having your client locked up that day. When there's a bond revocation, the solicitor is asking a judge to lock that defendant up because they've gotten back in trouble. But Judge Young tells Representative Stavronakis, we were told that the Larkin bond revocation isn't going because you're protected. Representative Stavronakis replies, that is correct. Judge Young then states, okay, why are you here? So if you're protected, why are you here? At which time, Representative Stavronakis, all in the transcript, tells Judge Young that he's here to waive protection on a guilty plea he wants to do, but he's refusing to waive his protection on the 2 or 3 bond revocations he has in front of Judge Young. The lawyer legislator is directing the judge how to call his cases. There's a problem with that. And Judge Young goes on to say, I haven't seen that order, but that doesn't seem like it's in the spirit of things. But ladies and gentlemen, there's nothing the judge could do. That is wrong. And let me ask you this. How do you think the optics were of that exchange for not just the judge and the solicitors and the attorneys and the public defenders, but also the victims and the defendants in that courtroom? Think about that. I know you're a judge, but you can't lock my client up today. I'm here because I want to do a case, but you can't lock my client up today because I'm a lawyer legislator and I'm protected. All right, this is another specific story that the solicitor and I just found out about very recently. This next instance I wish to discuss happened earlier this year, but again, we just found out about it within the last 10 days to 2 weeks. A judge put out word that the judge needed to speak to the assistant solicitor on a case. The assistant solicitor went back in chambers, and the judge told the assistant, I'm friends with the JMSC member. He represents this defendant. He wants to be here for his bond hearing but can't make it. What's the defendant charged with? The assistant solicitor says, trafficking heroin. The judge immediately says, well, I'm going to give him a bond. I mean, never mind that the defendant was convicted of voluntary manslaughter and got a 20-year sentence in 1992. Never mind that he has a 2007 trafficking heroin conviction where he got 7 years in prison. Never mind that he was already out on possession of drug charges when he picked up this trafficking heroin that the JMSC member called the judge about because he can't make it to the bond hearing. Never mind that he's facing life without the possibility of parole. Before the hearing, the judge says, I'm going to give him a bond. But it gets even stranger. Somebody tell me that a non-JMSC member has ever been able to do this. The judge in chambers gets the JMSC member on the phone and says, we're going to do the bond by phone. And the judge has his cell phone taken down to the holding cell so the convicted drug dealer and killer can use the judge's cell phone to talk to the JMSC member, his lawyer. I've heard a lot of crazy stories in my time in 30 years, but I've never heard of a judge allowing a convicted killer and drug dealer use his phone while he's in a holding cell. Never mind the issue about the potential of illegal contraband to a defendant. And I've never heard that happen with another lawyer, but it happened for a JMSC lawyer and his client. The deputy then brings the phone back to the judge. They go back out in the courtroom and they set bond with the judge holding the cell phone up for the JMSC member to hear it, and the defendant got a bond, and he is now out on our streets. There are a lot of problems with that preferential treatment case. A lot of problems. This is one that we've all heard a lot about, and it came up today, Gerard Price. And again, in recent months, unfortunately, we've heard about a lot of crazy cases involving Representative Rutherford for whatever reason. More than this, I think there's been 3 or 4 cases that have been reported in the newspapers about Representative Rutherford. And I can tell you, it just seems like all the bizarre cases that we see as solicitors always involve lawyer legislators. Weird ones like this. Todd Rutherford, representing a dangerous convicted gang murderer, goes back in chambers. The judge asked me, with the solicitor, who goes along with it. And the judge asks, what do you want me to sentence him to? Rutherford tells him and the judge gives it to him. And then they all agree to sign a secret order to be sealed forever. I know the victim's parents, Carl and Lily Smalls. I know them very well because I tried Gerard Price. They deserve better from our justice system than that. An automated call telling them that they know, to let them know that their son's killer is going to be released early in the next 2 hours. And they didn't know where to turn. They went to the solicitor's office, who couldn't help. They went to the governor's office, who did not help at that time and couldn't help. Nobody could help because it was a sealed secret order. And yes, I agree with 3 of the justices out of 5. It was a remarkably egregious set of facts. And then once it's exposed, Carl and Lily Smalls had to listen to a JMSC member talk about how Gerard Price is a victim. It was outrageous. I've tried a lot of murderers. I've put people on death row. Price is the only defendant that I've had to get an armed escort from the courtroom to my car and back when I tried him. That's how dangerous he is. And I was in the garage, and I had to get an armed escort, not of my wanting. When he escaped, Chief Keel called me to tell me we need to do an analysis or whatever on this guy. Where are your kids? Asking me where my children are. That's how dangerous Gerard Price is. But to JMSC member Todd Rutherford, he was a victim. And then we read about this case, the second one and the last one I'm going to talk about with about Todd Rutherford, just months ago. And again, why is it all the weird cases involve lawyer legislators or JMSC members? He pleads his client to a drug charge carrying a mandatory minimum sentence. His client already had multiple drug convictions, drug trafficking convictions, had already been to prison before. And Rutherford is able to convince a judge to allow his defendant to remain out on bond after his guilty plea. This multiple convicted drug trafficker is going to get to stay out on bond after his guilty plea to get a pre-sentence investigation or a PSI. 30 years, I've never heard of someone who's been to prison on multiple occasions getting a PSI for drug trafficking. Never seen it. But it gets worse. Oh, and of course, and let me point this out. By giving him the PSI, it's no secret, the plea was in the month of December. It was in the month of December. The pre-sentence investigations aren't going to be done until January or February. So what does the PSI allow the defendant to do? Stay out on the streets until at least August, because you can't order Todd Rutherford back to court even to sentence a defendant who's pled guilty to drug trafficking. No preferential treatment. But it gets even worse, because not only did the defendant not come back in August, he stayed out long enough to pick up a domestic violence charge in another county and get out on bond again. The defendant wasn't sentenced in August. He wasn't even sentenced that year. He wasn't sentenced the next year. He wasn't sentenced the year after that. It took 3 years before they were able to get him to court and get him sentenced. And sadly, if this hadn't been reported in the press, I'm not so sure the defendant would have been sentenced today. This just happened back in August. If it hadn't been reported in the press, I don't know that he would have been sentenced back in August. This is a very minor issue in my circuit, and I'm just mentioning because it's so recent. We filed this yesterday. Again, why do strange cases always involve lawyer legislators? And honestly, we could spend a day talking about other cases just like it. But this other one, we filed a motion. The defendant pleads guilty back in October of 2022. And before I go further, the judge on this case is a great judge. The lawyer legislator on this case is a great lawyer legislator. Best you could ever deal with as a solicitor or an attorney. But the state recommends a brief prison sentence at his guilty plea in October of 2022. The lawyer legislator asks the court to accept it, the judge accepts it, and the defendant is supposed to go off to prison to serve their sentence. That was 13 months ago. However, the judge accidentally writes the wrong sentence, and the defendant gets out early. It was an accident. He wrote down the wrong sentence. There is no doubt, it was in my mind, that it was an honest mistake. But when we bring it to the judge's attention that you made this mistake and that the case law is clear, your oral order of the sentence controls the sentence, so just please amend your order so the person can go back to prison, the judge won't sign it now because the lawyer legislator objects. So now, 13 months this has been going on, and we've had to file a motion, put it to paper, to try to get the judge to bring this defendant in and get this person back in prison. It's just another example of how the optics are bad. And don't forget, there are victims on this case. This was an important case to them. And they see that their defendant is out when they shouldn't be out. This is Judge Christy Harrington. And I'm going to talk to you about her experience with the JMSC. And this is important, Representative Caskey. I want you to hear what happened to Christy Harrington. And I'm glad Representative Rutherford's here because he can hear it too. Back in March of 2022, I'd already spoken about the need for judicial reform in Greenville and Newberry and other places. And I, like many members of the bar, had heard rumors that the reported reasons for judicial candidates, especially sitting judges, dropping out of races at the JMSC level is not the whole truth. I'd heard those rumors. The perception amongst my peers and other members of the bar is that there's always a backstory involving a disgruntled JMSC member. A JMSC member who had a judge in their line of sights and they wanted to take him out. So that March, I decided to start reaching out to those judges who were forced out of the JMSC or forced to withdraw. Many of them talked to me, and they had fascinating facts and stories to tell me, but only 2 would let me tell their story publicly. One of them is here today, Judge Tommy Russo. The other one, Christy Harrington, wanted to be here today, but she's litigating a case out of state. I actually had one former judge who wanted to come to my office with documents. They reached out to me. Yes, Pasco, I want to talk to you about it. I'm going to bring documents. They requested the in-person meeting, but in the morning they were supposed to come. They called me and apologized and said they couldn't go through it because they feared retribution because they still practice law. But the two former judges that did allow me to tell their stories were Christy Harrington and Judge Tommy Russo. Last week it was discussed how the JMSC, quote, weeds out bad judges, and that the JMSC should be commended, not condemned, for not having bad judges reelected. I could not disagree more. The JMSC process is rigged, and a process that I can't even understand the rules of because they seem to change depending on the candidate, and I can tell you that from my own experience in dealing with the JMSC. And it contradicts the purpose of what being qualified means. Justice Kittredge told y'all last week, it's a low threshold. And yet the JMSC member deprives you, every member on this panel, the right to vote up or down on a judge like Judge Harrington when they have them in their line of sights. The JMSC does not weed out judges. They berate them, they threaten them, and they intimidate them until they drop out. That is not a system we should support. Judge Harrington, who I knew, and I knew her very well, my lawyers knew that they had to be prepared when they went into her courtroom and that she was fair, that she was no nonsense. She was known for her unequaled work ethic. In her 10 years on the bench, she tells me she presided over 250 jury trials to verdict with a 96% affirm rate when she went before the JMSC in 2017. Interestingly, former Judge Harrington, to this day, still teaches ethics at the National Judicial College in Reno, where you pay to send our judges to learn ethics. She teaches them ethics. She served as the chair of the faculty committee and has been on the board for 6 years after she went through her JMSC experience in the fall of 2017. So we're going to talk about her experience, and very importantly, again, she wanted to be here but couldn't. In the summer of 2017, Judge Harrington had filed for re-election. She had already been elected and re-elected on 2 other occasions to be a circuit court judge. On a Friday in late August of 2017, on that Friday afternoon, or sometime in Friday, an assistant solicitor went to her for scheduling purposes because they had a murder trial scheduled for Monday, and the defense attorney wanted a continuance. On the eve of trial, the defense attorney wants a continuance. Judge Harrington was the chief administrative judge, and it was her job to set the docket and to set the trials. The murder trial had already been continued on previous occasions because of the attorney. It involved out-of-state witnesses, and the family was set to come for the trial on Monday. And the defense waits on the eve of trial to ask for continuance. So with the assistant solicitor in chambers, Judge Harrington called the attorney. The attorney at that time was JMSC member Peter McCoy. He was on the JMSC when he was asking for that continuance on Friday. He asked for the continuance. The judge explains to him that it's an old case. It's been continued before. It involved out-of-state witnesses. It's the 11th hour, and it's not right to ask for a continuance unless you have a good reason. She asked Mr. McCoy, do you have legislative protection next week? And he said no. And she said, you need to be here Monday. But Mr. McCoy then responds, that's Judge Murphy. I don't want to go before her. Harrington says, sorry, that's the judge on Monday. I want to divert away for 2 quick points, and then we're going to get right back to Chrissy, and I'm going to tell you what happened to her, Judge Harrington. First point I want to make is that's Judge Murphy, that's our judge. And she's as fair and as good as any judge there is in the state. It seems to me, Representative Whitmore, that we maybe need more women on the bench because the 3 judges that I'm talking about who have stood up to lawyer legislators seem to be Judge Jefferson, Judge Murphy, and Judge Harrington. Yet, I'm told we're the only state in the union that doesn't have a woman on the Supreme Court. I think that is evidence enough why we need to change the system in one way or another. I'm also told, Representative Thigpen, that come this July, once my friend Chief Justice Beatty is gone, we will not have one person of color on the Supreme Court. And that we will only have maybe one person of color of the 14 appellate court judges in the state of South Carolina. Honestly, that by itself is drastic evidence as to why we need some kind of change with our system. I don't understand why we're defending this system. It makes no sense to me other than to help people out that want to keep their power on JMSC. And again, I'm not asking for drastic change. I'm asking for lawyer legislators to be removed from JMSC because of what happened to Judge Harrington. Let's get back to her. She tells Peter McCoy no continuance. She knows Peter McCoy's upset. And not long after she hangs up the phone with Mr. McCoy, she immediately calls another circuit court judge, a good friend of hers, and says, I'm in trouble. I didn't give Peter McCoy a continuance, and I think I'm in trouble. I think he's mad at me. Representative Newton, that is not an independent branch of government. That is a judiciary scared that they're not going to get to keep their job because they offended a JMSC member right before she has to go in front of the JMSC. That story by itself, if it ends right there, is why we have to take lawyer legislators off of the JMSC. That story by itself, calling another judge, I'm in trouble because I upset a JMSC member. That is not an independent branch of government. That is not what Madison condones in how we pick a judge. We have judges scared because they don't want to offend JMSC members. The following Tuesday, that was on Friday, on the following Tuesday, Judge Harrington gets a call from Representative Leon Stavronakis. And Leon Stavronakis tells Judge Harrington, what did you do to make Peter so mad? I was with him in Merle the other night, and I've never seen him so mad. She knew then, again, she's in trouble. And she called her JMSC lawyer, who told her, no, you don't have anything to worry about. You're unopposed. No one has filed an official complaint against you. You got this high bar standing from the Citizens Committee, you got nothing to worry about. But she knew she did have something to worry about because she offended a JMSC member. The hearing comes along, I think it was November, December, and it was brutal. There are all kinds of articles about it. They berate her. They threaten her until she withdraws. At some point, a member of the JMSC member sitting in the back right now read Judge Harrington her rights. Her rights. First, they accuse her of being mean. When that didn't pan out, they accuse her of having debt and too many student loans, which ended up being paid off within the next year or two. The JMSC member sitting in the back mocked her and told her she couldn't afford a sandwich. When that didn't pan out because her credit score was too high, they said she had contact with the legislator. And when that didn't pan out, they turned to intimidation. They threatened her, and she dropped out. They intimidated her to the point where she had no choice but to drop out. Read the articles. It's brutal. That is not a system we need to be proud of. And you know, in my many conversations with Judge Harrington, she would always tell me that there were people that saw what happened, David. And she would tell me that John Nichols, the director of the Office of Disciplinary Counsel, was in attendance. And she told me, David, she told me this just last week, he apologizes to me every time I see him. And then she told me other things that John Nichols told her. So last Friday, I decided to call the former ODC director. Even though I trust Judge Harrington, I knew she wouldn't lie to me, I decided to call him because I wanted to make sure that what I'm about to tell you is right. When I say that what happened to Christy Harrington is that the JMSC that day was rotten to the core. Rotten to the core. And I promised John Nichols last Friday that I wouldn't quote him directly, but I now feel very confident in quoting Christy Harrington. John Nichols was asked to come to Christy Harrington's hearing by a JMSC staffer. He didn't even know what it was about, but he figured, I'm about to be the director of ODC, I'm invited, I need to go. Invited by a staffer. He got there, he sat in the back, and before Christie's hearing got started, Chairman Luke Rankin asked John Nichols, no, come down and sit on the front row. The JMSC manipulated John Nichols, the director of ODC, to sit on the front row to intimidate Christy Harrington, because she said when she saw John Nichols, she knew it was over. They were coming for her. John Nichols has since, according to Christy, on multiple occasions apologized to her for letting him be used for this injustice. She was in their sights and the fix was in. And what proves that even more, and I'm going to finish right here about Christy, what proves it even more, Ms. Harrington, is that do you know that after the JMSC threatened and intimidated Christy Harrington from her post, after they read Miranda rights to her like she was an accused criminal, after they called her unethical, do you know who brought Christy Harrington on as an assistant to the office, a disciplinary counsel to handle complex disciplinary and ethics issues? John Nichols. Weed out bad judges? Commend the JMSC? No, condemn the JMSC. So she's not qualified to be a judge in South Carolina, but she can teach our judges and she can handle complex ethics issues. And I'm going to tell you something else that I wasn't planning on telling you, and that she doesn't even know about it. Only Solicitor Scarlett Wilson and Judge Diane Goodstein know this. They reached out to me, Solicitor Wilson and Diane Goodstein, asked me to go to Judge Harrington's hearing back in 2017. Solicitor Wilson couldn't go because she was in federal court and couldn't attend. Obviously, Judge Goodstein couldn't go, but I think her husband went. I might be wrong, but I think he went. They knew she was being treated unfairly. I think they knew the inside baseball a lot better than I did. And they thought for whatever reason, maybe I could go and help. And I told them I would try reluctantly because I wasn't as close with Judge Harrington as they were. And I didn't know all the circumstances. But right before I headed to Columbia, I spoke with the JMSC member. I was literally walking out the door and the JMSC member said, don't bother coming. She's done. She's toast. Nothing you can say is going to help her. We want her gone. So I didn't go. I wish I knew then what I know now, because I sure as hell would have gone today. About perception, Representative Caskey, I was just doing some research on Christy Harrington's race, looking for articles. And I saw this op-ed for the first time last week. It was an op-ed written by Mr. Roy Willie. I think he's a Charleston attorney, Representative Whitmore, but I'm not sure. I think he does a great job of explaining what the everyday member of our South Carolina bar thinks about the JMSC and our process of picking judges. He said, as attorneys, we believe in due process. Judge Harrington's process was an all-male commission that badgered and forced her to withdraw. He further goes on, as far as optics, to say, legislators electing judges is a strange thing, and it seems to me that this situation is a very good argument against it. Watch to see if a legislator or spouse of a legislator is picked to fill Judge Harrington's seat. That will tell you most of what you need to know about the politics of the process. I'm not saying it's true. I am saying what happened to Christy Harrington is an injustice. But I'm not saying any of that is necessarily true, what Mr. Willie said, but that's the perception of the JMSC process in South Carolina. That's the other problem we have with our system. People see legislator spouses, siblings, children, law partners, cousins, best friends getting elected. And it taints the process for everyone else. It taints the process for great judges like Maite Murphy, who's, in my opinion, one of the best judges in the state. But it taints it for her. And Mr. Willie was wrong. Mr. McCoy's spouse didn't get elected in just Judge Harrington's spot, but only because she got elected that year in another spot. And people just roll their eyes about it, even though all I hear about Judge McCoy is fabulous things from Solicitor Wilson and others. But people still roll their eyes. But instead of electing his spouse, who was said was already being elected, we got his best friend. We got one of his best friends, Bentley Price. Mr. McCoy spoke at length for anyone who was at Bentley Price's investiture. He spoke at length about how he worked hard to get Bentley Price elected to the bench. Judge Price has been in the news a lot lately because of questionable judgment. And at times, the attorneys on those questionable cases have either been Mr. McCoy or another legislator. In fairness to Judge Price, this opinion piece done on him a couple of weeks ago, criticizing him for dismissing a pedophile's charges, did not involve a lawyer legislator. I don't think it involved a lawyer legislator. But this recent case just a couple months ago, and again, I'm just talking about recent cases. This recent case just a couple months ago does involve a lawyer legislator representing a defendant charged with murder. The defendant's name is Dartez Ferguson, Jr. There are several other stories, including one very recently on Live 5, of how disrespected the victim's family felt in Judge Price's courtroom. Leon Stavronakis, lawyer legislator, represents Mr. Ferguson. The state moved in April to revoke Mr. Ferguson's murder bond because they believed they could establish he was violating his GPS requirements. It was scheduled to finally go before Judge Young, who we talked about earlier, this summer. April, think about that. Finally going to get to the bond revocation sometime, I think it was in late July. Representative Stavronakis, though, didn't want to go in front of Judge Young and emailed Judge Price, who is the chief administrative judge, and was able to get Judge Price to continue it to a later term that Judge Price presided over. Judge Price heard both sides and decided he would make a final ruling in about 10 days to 2 weeks later when he would get more information. But he did say, and this was on the news for the world to watch, it was on video on the 6 o'clock news. He said, but I'm revoking the defendant's bond until we get to that hearing in 10 days. And then the news reports showing it, but Leon Stavronakis protested, and the judge changed his mind, and he allowed the defendant to stay out on bond. The victims were present. Again, the judge said that they would reconvene in a couple weeks, but they never did. Instead, after some email exchanges with the prosecutor and Representative Stavronakis, Judge Price signed an order letting the defendant stay out on bond. So he's still out on bond. This is far from Judge Price's first act of preferential treatment of Representative Stavronakis, and I would invite all of you, go to the Ninth Circuit Solicitor's Office's website for the public to see, all of you to see, what the bar, the bailiffs, and everyone in the courtroom see every day, which is preferential treatment that he gives to Representative Stavronakis. Justice, I keep calling you Justice. Representative Bamberg, you want specific judges, I'm giving it to you. And I'll give you, this was another case that now involves my circuit. It involves both the Ninth Circuit and my circuit, and the defendant's name is Savion Scott. Again, very recent, just happened in the last month. Mr. Scott is arrested on 5 separate occasions for mostly drugs, always bailing out in magistrate's court. He was out on 5 bonds totaling $135,000. Remember that number, $135,000. In September of 2022, he was charged in Charleston County for attempted murder and a slew of other charges for allegedly firing a gun into a crowd in downtown Charleston. And his bond was denied by the magistrate, so he's finally in jail, bond denied. 5 charges, now he's picked up a 6th. The state moved to revoke all of Mr. Scott's previous bonds that totaled $135,000. And of course, the state was asking that his bond stay denied on the attempted murder. The hearing was set for January the 3rd. And honestly, I don't know that I ever would have thought that a judge would have let this defendant back out on bond after the attempted murder. And I mean that. On January 2nd, the day before his bond hearing in circuit court, former JMSC member Peter McCoy, who told the world he got Judge Price elected, filed a motion to set bond on behalf of defendant Scott, and that McCoy's appearance was, quote, limited for appearance for bond only. He wasn't even going to represent him on his charges. He was just there to represent him to get a bond. And I don't know that this is true, but I am told that at the bond hearing, he didn't even say a word. He just stood with his client. I'm still waiting on the transcript of that. Because they have the hearing on January the 3rd, and not only does Judge Price not revoke the 5 other bonds that were totaled at $135,000, not only does he refuse to deny Mr. Scott's bond on the attempted murder, he literally totals all of his bonds for just $100,000. It's the only defendant I've ever known to get rewarded and get your bond lowered for allegedly committing attempted murder. $135,000 to $100,000. Now, he did put him on electronic monitoring, which was good, because I think it does help us in our Dorchester case, because a few months later, Savion Scott was arrested for murder in my circuit in Dorchester County, out on that $100,000 bond by Judge Price. This is the judge that JMSC member McCoy got on the bench after they berated Harrington into dropping out. Judge Price goes before the JMSC today. Will he be weeded out? Will they ask him about news reports on Live 5 about how he rolls his eyes at African-American victims in his courtroom? Will they ask him that? Will they badger him the way they badgered Christy Harrington about her student loans? Will they badger him about his questionable expenses? I guess we'll find out this afternoon. The last case I'm going to talk to you about, and I promise I'll shut up, is another recent one involving Judge Daniel Coble here in Richland County. And again, it's not about whether it's a good ruling or the right ruling. It's about the optics of what happened here. Y'all may recall there was that big $75 million case that was brought up. One of the lawyers was a JMSC member, another one's a state senator. And Judge Coble ruled in favor of the JMSC member and the senator. Did he rule correctly? I don't know. I'm not a civil lawyer. I don't know. But I know that the optics of it looked horrible because Judge Coble is going in front of the JMSC member this week, or went last week in front of that JMSC member. I mean, a week before he has to go in front of the JMSC, he's ruling on a case involving a JMSC member worth millions in a case involving millions and millions of dollars. The optics are horrible. He shouldn't be put in that position. And it was reported in the news about how he just made this ruling for that party, and he has to go in front of them in the next couple of weeks. It was in the paper. He shouldn't be put in that position. And unfortunately, there's another backstory to it that makes what happened in that case even more suspect in the eyes of many members of the board. I think many of you will remember this fiasco involving Judge Strickland. The Richland delegation tried to unlawfully ouster him. It was absolutely nuts. It was crazy. The delegation convened, failing to adhere to the FOIA laws by not providing 24 hours notice before they took that vote to ouster Judge Strickland. They met anyway, voted to ouster him. One question that some in the bar had was, why didn't Strickland or one of the legislators who supported him, why didn't they try to get a temporary restraining order hearing, a TRO hearing, to stop the vote? Well, they tried. And the lawyer, Chris Kinney, is willing to come here and testify to you anytime you want to hear from him, Mr. Chairman. He says he's willing to come testify to what I'm going to tell you and more. He tried, but he was denied not just the temporary restraining order, and he was denied the hearing. The delegation meeting was to begin at noon with legislators, a lot of lawyer legislators. Chris Kinney got to the Richland County Courthouse at approximately 9:15. 9:15 in the morning to have a quick emergency hearing in front of a circuit court judge to ask for the TRO. And these are matters, any TRO, it's usually a matter of pressing urgency. Got to get it heard. Happens every day in courthouses across America. Getting a circuit court judge to simply have a hearing to determine whether the legislature should stop doing something, getting that hearing is a simple thing to do when you have a separation of powers and the judge doesn't have to worry about offending legislators that he might be signing an order against. But not for a judge who's up for re-election. Mr. Kinney gets to the courthouse at 9:15. The judge he needs to have that quick hearing in front of is Judge Coble again. Judge Coble is in chambers. Mr. Kinney will tell you the clerk's office was awesome. They went back there, told the judge, got Mr. Kinney out here, pressing matter, has to have a TRO hearing. You got to decide whether to grant it or not. 9:15, 9:30. He had those documents in his hands, Judge Coble, no later than 9:30. Remember, got to have the hearing by 12. Have the judge decide yay or nay. 10 o'clock, the judge stays in chambers with the door shut. 11 o'clock, the judge stays indoors in chambers and still refuses to see Mr. Kinney. 12 o'clock, the judge stays in chambers. Law clerks and clerks of court were going in there to try to get the judge to see Mr. Kinney, knowing it was pressing. Finally, at 12:15, the judge opens the door, sees Mr. Kinney, and says, "It's too late now. The meeting has already started." That is not exactly an act of a profile in courage. I mean, just give the man the hearing and give it up or down. 3 hours. He made him wait, and it appears in the eyes of Chris Kinney, who had a conversation with the judge, a very heated conversation at 12:16 p.m. It appears that he intentionally made him wait to make the issue moot because he didn't want to decide the issue of whether he should grant a TRO against those legislators or not. That is why Madison says you can't pick a judiciary dependent on the legislature. That is why so many people question whether we have an independent judiciary. And it encapsulates why people have lost their interest, Mr. Chairman, in our system. I had an eloquent 20-minute close that I was going to do, but I'm going to pass it over to Solicitor Brackett now.
We're going to divert just a little bit because you've gotten all of my members so excited. They're
good.
chomping at the bit. So, Mr. Brackett, we're going to come to you in just a moment. I will admonish both sides of this not courtroom that we're going to have some decorum. I know these are contested issues and heated issues. I want each, the questioners and the answerers and vice versa to respect each other, or we'll cut the questioning and the answering short in that regard. So, thank you. Mr. Caskey has first question.
Thanks, Dad. That is an admonition that I have brought on by, let's say, custom and habit. Solicitor Pasco, I want to just first acknowledge that you have offered many critiques that merit further consideration, that are worthy of our time and thought. And I'm not here to dismiss those out of hand just because I have more questions about what you've offered. And let me also thank you for your service to the state as a solicitor. I respect that and am grateful for it. And I'll also add, because I think it's relevant to some of the points you raised, that pressing people in power is always difficult. It's always a challenge, and I might need to fly to Charleston from now on to make sure that I don't find myself on the other side of this. But your remarks left me with one recurring thought, and that was that I am so grateful that in the court of law we have the confrontation clause, that our Sixth Amendment gives us an opportunity to challenge the things that are offered, because as you talked, I don't know how anybody could not vote to convict. I think, though, because you talked about optics, we ought to think about what that really entails, what that really means. And optics, another word for it might be presentation. How is it presented to the decider, the decision maker? And again, I can understand why you would be particularly emotional in a case like Gerard Price. I would probably quibble with you that it wasn't 3 of 5 justices that said that was egregious conduct. As I read Justice James' dissent, he clearly rejected his conduct and said this was a bad individual who'd done some terrible things. But what I can't just skip past is when the implication is that the order was signed by Judge Manning because Representative Rutherford was a member or is a member of the Judicial Merit Selection Commission. I can't help but say, wait a minute, Judge Manning was already retiring at that point. He was never coming back in front of the JMSC. Judge Manning had nothing to gain or lose by rendering the decision that he did. Again, let's also acknowledge the legal problems with that case. But insofar as the implication from your statements today is that Judge Manning acted in the way that he did because of Representative Rutherford's status as a member of the JMSC, I don't think that withstands scrutiny. And the same could be said for the Lawyer Legislator Order of Protection and Chief Justice Beatty. I'm not here to defend Representative Rutherford, but Chief Justice Beatty is not coming back up before the JMSC. He's going to retire. And so, again, if the implication is that those decisions are only rendered because of the JMSC status of one of the litigants' attorneys, that doesn't work for me. I guess I heard myself talking there. The Lawyer Legislator Order of Protection didn't require representation by as an attorney there, so let me just recognize I said I misspoke. But Chief Justice Beatty's decision, whatever they were, they're not contingent on the JMSC. And again, I think you raise excellent points about the Lawyer Legislator Order of Protection. But I also can't escape the thought that that is the province of the court to issue its orders or not. And you have eloquently articulated the reasons that Madison laid out about the needs for separation of powers. And yet, it seemed to me during your testimony, you took great pride as a member of the executive branch in influencing the judicial branch to issue that order. And so that at least is incongruent. Again, I don't want to rush past it and say that I think it's all fine. It is not all fine with respect to Lawyer Legislator Orders of Protection. I think it is necessary, as I think you said, that we need to be able, if we're going to have a part-time legislature and we're going to have lawyers who serve in that part-time legislature, there has to be some mechanism for protecting lawyers who serve in the legislature. I'm not here to endorse the current version of that. I think that is worthy of further discussion, and so I applaud you for bringing that up. Consequently, and this sort of goes to my point of optics, I don't want to get into the specifics of any of the cases that involve Judge Coble or Judge Price, because they are both being screened by the JMSC, and as soon as this is done, I'm going to have to run back over there, and for obvious reasons, I can't get into that. But I would be remiss if I didn't point, insofar as we're talking about optics, to the fact that this newspaper article you bring up, at least in several instances, begins with Krangle said. John Krangle, who is a failed political partisan candidate, who is an activist that for whatever reason the state newspaper feels compelled to habitually say, John Krangle, longtime ethics watchdog, as if there's nothing else that can be said about him. So instead of identifying the proponent of the story as more specifically, we just are left with, well, Krangle couldn't possibly have any motivations in all this. And so, again, I think that goes to my concern about optics. what is the public perceive? Well, what is the public told? And I think it's incumbent upon our friends in the media to make sure that story is told with fidelity to the facts and not for purpose of advancing any agenda. I think it's also relevant here that all lawyers, whether they are legislators or not, are subject to the jurisdiction of the Office of Disciplinary Counsel. And at any time, those complaints can be made and they can be adjudicated. And so I don't think it's consistent with my understanding of how that lawyer discipline process works to suggest that, like, oh man, everybody who saw wrong was left without any recourse. There was no remedy. That's not right. There are remedies available. There are remedies available when a judge acts in violation of the codes of judicial conduct, the canons of judicial conduct. There's a commission on judicial conduct. There is a mechanism for dealing with that. And so I would hate for anybody listening to this to think that, oh, well, we just have to take it because JMSC exists. I don't think that's right. And in the same way, and this is my last point, and then I will give you a brief minute reply because I think that would be pretty chicken of me to not do, but I do have to get back over to the Gressive building. I heard testimony about backlogs and who can call the case and the references to Langford. And Langford was the law of the land, but I think the Supreme Court made very clear in its General Sessions docket management order that was issued on May 24th, 2023, that State versus Langford held unconstitutional a statute giving the solicitor the exclusive authority over docketing and calling for cases. But then in the very next paragraph went on to say the Langford court did not prohibit solicitors from being involved in the docketing process as long as the trial judge has ultimate authority over the setting and calling of a case for trial. Unlike the common pleas docket, one lawyer, the solicitor, is responsible for the prosecution of almost all cases comprising the dockets. Therefore, solicitors have substantial input into the creation of the trial docket. And solicitors have the exclusive control over the plea docket, which I think we would agree is the mechanism by which we handle the overwhelming majority of cases in this state, is through the plea docket. And solicitors alone control that process. And so when I look at the data, which we've not been able to do, or at least we are conflating that with anecdotal evidence, I look in your circuit and see that there are, as of November 1st, 2023, 256 indictments that are over 3 years old. And when you drill down a bit deeper, you see in Orangeburg, murder case that's 3,474 days old. Drug trafficking, 3,000 days old. DUI, felony DUI, 2,970 days old. And on and on and on for a total of 400, these are 431 warrants. So, the same story in Dorchester, 2,205 days old, and on down the list. And this isn't to criticize you in the first instance, because I recognize there's a lot of reasons why cases can't go to trial. Did you have to have, a mental health evaluation? Do you have the DNA evidence back? Do you have various other reports from law enforcement you need to go to trial? Are witnesses available? Is somebody on the run? What I'm suggesting here is, and again, I wish I was able to have a longer and more full dialogue about this. What I'm suggesting is it's unfair to suggest that it's the judiciary that's causing that backlog and that it's JMSC causing that backlog.
What, does he get to go on and make mistakes
Yeah.
like that?
That's the way it works.
Okay, good, go ahead, keep stating, and then I'll get my last word.
All right. What I'm saying is, if you're suggesting that it's the JMSC that are causing these backlogs, I think that is a misrepresentation of fact.
What is he talking about? Can I go now, Mr. Chairman? Thank you.
And so my question, thank you, Mr. Speaker, my question to you, Solicitor, is what's your reaction to that? I'll give you, you can have at it however you want.
If you weren't a Marine, I'd tell you what my reaction to that was. No, I mean, wow, talk about taking pot shots, whether it's a John Krangle or David Pasco. And I say this with all due respect. You have absolutely no idea what the docket order says and what it's about, or the Lankford opinion. You guys are lost on Lankford and the docket order. You want to take pot shots at my office? We just tried a murder case last week, won it, got life without parole. That's what we do. There aren't many circuits, if any, that have a higher trial conviction rate than the First Circuit. And when we convict them, my judges give them life, whether it's Murphy, Goodstein, or Taylor. But I mean, really, where do you want me to start? You're misstating so many things with regards to the docket. Solicitors have never controlled the docket, especially after Lankford. What happened in 2012 after Lankford, and I'll address it briefly so maybe you can understand it. We were all walking through the desert, wondrously trying to figure out how to run the docket. And finally, this past year, and to his credit, he's the first and only Chief Justice to actually do it. Other Chief Justices have tried and couldn't do it, and Beatty did it. He got that order done with Justice James's help and others, telling us how to run the docket. That is an order from the Chief Justice telling David Pasco and other solicitors how we're going to run the docket. And I believe, my opinion, it is a great order. But, I mean, your little pot shots about and who's blaming the JMSC for the backlog? I never did that. I'm blaming the JMSC for the horrible optics of what goes on in this state when the people see preferential treatment go to the JMSC members. And I'm blaming the JMSC for being a rotten commission when they do things to Christy Harrington like they did. That's all I got.
So I appreciate that, Solicitor Pasco. Again, insofar as my remarks came off as a pot shot at your office, let me take that back. That was certainly not my intent. Sometimes I talk faster than I think. So that's not the intent here. What I'm interested, though, is getting to the truth. And if your allegation is not that the JMSC is causing the backlog, I appreciate the clarification. What I would quibble with you about is the implication that what I read to you out of the May 24th, 2023 General Sessions Docket Management Order is not what it says. I'm not reading into this. I'm reading you verbatim the words that are here. So, again, everybody can look it up for themselves, what the order says on its plain face. It, on page 3, 4, solicitors have substantial input into the creation of the trial docket.
And who signed that order?
Chief Justice Beatty, Justice Kittredge, Justice Few, Justice James, and Justice Hill.
That's what they are telling me. Yes, sir. That is their order telling us that and telling the world that. Yes,
So I don't understand how we have a dispute as to what the order says.
All right, gentlemen, I tell you, we got 1 hour left. We can debate the backlog at some subsequent time. Mr. Caskey, I'm gonna move forward. I will tell you, members, too.
Yes, sir. Thank you.
Thank you, sir. I've got a number of you that want to ask questions. I've reviewed Mr. Brackett's PowerPoint. It's very similar in subject matter to what Mr. Pasco had. So I want Mr. Brackett to go ahead and share it because I think otherwise it's going to be Groundhog Day. We're going to be asking some of the same questions of Brackett we asked to Pasco. Then you can have the opportunity to ask them both questions. So, Mr. Brackett, I know you have a presentation too. Members, if you look at the bottom, the Judicial Reform Committee on the bottom left is in your materials if you choose to look at it on the screen. Mr. Brackett's recognized.
Thank you, Mr. Chairman. I appreciate the opportunity to be here as well. And I want to take just 1 second to concur with everything that that my friend Solicitor Pasco from the First Circuit said in his opening. We are not here, a couple of things that I keep hearing over and over again, we're here bashing judges. No, we're not. This is not the judge's fault. The judges are put in an untenable situation by a system that is rife for exploitation by a select group of lawyer legislators. And the second point, I said select group intentionally. There are many fine lawyer legislators that work every day in the courts. One of them drives past my office every single day on the way into his office in Rock Hill, and he has never once stopped in and tried to misuse his authority, and I have great respect for the people who could do something but don't. But that does not mean that I shouldn't disrespect and hold in contempt the people who do abuse the authority that they have. The people, some of whom were mentioned by Solicitor Pasco, and some of whom I'll mention now. Some of those people need to be taken into account, and the system needs to be fixed so that they cannot continue to exploit this. Some of the powers they have, the influence, the ability to intimidate a judge, the ability to stay out of court for 7 months out of a year, that is a marketable service that you can provide your client if he's charged with a crime. I can guarantee you, 7 months, you are absolutely home free. As long as we get to January 1st, baby, you don't have to worry anything until August. And even then, all I have to do is have some legislative function that I'm supposed to attend. We can't even get them into court for the 5 months that's off. We're in the off session now, and you're all here working. So it does happen, but then in the few weeks that we have that we can do something with these cases, we're all fighting to get to them because we've all got old cases with them. And they can't be in 2 places at once. So it goes on and on and on. And we just have to keep picking up the phone and explaining to the victims why their daughter's case, who was sexually abused, is now 7 years old. That's unacceptable. If you can sit here and conjure up some explanation for how this is a good system, I sure want to hear it, because I can't think of one, and I got a pretty good imagination. I know we have a limited amount of time. You have the clicker over there, would you spare? I don't want to, I'm going to move quickly because I know we have a limited amount of time and I want to be available to question. I really do. I'll stay here all day. The cameras can cut off. I'll stay here until you have all your questions answered because this is a subject that's dear to my heart and y'all need to know why it needs to be fixed. So I put this on paper. I'm looking down at my slides because when I came in and I looked up there, I was like, I don't know if I'm going to be able to read my PowerPoint. So I had it printed out. It's in front of me. So you see me looking down. I'm looking at the same thing you are. I didn't come here to bash individual legislators. If you want to know who I'm talking, I'm going to mention some because it's just in the context of the story. I can't help it. But I'm not going to bash them. It's not the purpose of this. The system is flawed. I'm not going to mention judges' names, even if you ask me. I'll mention the case, and you can look it up publicly. But I am so determined not to appear to be assaulting the judiciary, who I believe, and my colleagues believe, are the victims in this situation. They are denied. I don't know how they'd rule in cases sometimes, because I don't think they're free to rule as they wish. They're stuck ruling how they think they have to rule. It's the consistent theme. They are definitely under pressure in these situations. No system is perfect. Some are grossly imperfect, and that's what we have here. I want you all to understand, I'm going to go through some cases in a minute, something that the non-lawyers or the people who don't practice in criminal court need to understand. Okay, if you've been practicing in criminal law for 30 years, like I have, like Solicitor Pasco has, like many of my colleagues have, like many assistants and deputies throughout the state, you know the value of a case, right? If you're a plumber and you've been a plumber for 25 years and your friend says, come over to my house, look at my bathroom, I want to remodel it, I want to put all new fixtures in, you could pretty much say, this is how much that's going to cost. It's going to take me about 6 hours and the fixtures are going to cost this, off the top of your head, because if you've been doing it for 25 years, you pretty much know, right? Well, so do lawyers. We look at a case, we read the facts, we see how strong the evidence is. We look at the defendant. What kind of a record does he have? Is there anything particularly aggravating about this case that's going to outrage the public or outrage a judge's sensibilities when he hears about it? We factor all that in. How old is the person? All these details. We look at that and we go, I think the judge, you tell me who the judge is, that's important too, because different judges have different issues. Justice Beatty, I practiced in front of the chief when he was a circuit judge. Everybody knew. If you had a gun when you were breaking the law and you pled in front of Chief Justice Beatty on the circuit bench, you're going to jail. And everybody knew that. So you need to know who the judge is. But I could look at that case, Solicitor Pasco could, and we could predict within about a year or two of where we thought the sentence was going to land, and we're pretty dead on every single time. Because it's just, after doing it 30 years, you know the value of the new fixtures. So when I tell you these things, some of you might not understand when I say, and here was the sentence. I want you to understand all the people in the courtroom, the public defenders, the private attorneys, when they see a lawyer legislator get a result, they know they wouldn't have got, everybody in the courtroom's looking, going, how did he get a bond on that? How did that guy get probation? I couldn't have got him probation. Clarence Darrow couldn't have got that guy probation. What's at play here? And after seeing it over and over again, you figure it out. Last thing I want to tell you is there was a lot of talk last week about all the work that the bar does. I appreciate all that, and this is not to denigrate them either. I believe they're sincere. As the Attorney General said earlier today, they work hard, and then they see somebody they feel is totally unqualified actually pass through screening and get elected, and they're disheartened because it's like, what's the point of all this? We said that we didn't think this person was good, yet they sailed on through and got elected. When I was listening to you guys talking earlier and Representative Caskey questioning him on that, I was like, it reminded me of the old saying, what is the sound of a report that's read in the forest? If nobody's around, does anybody hear it? Nobody listens. If they have made their mind up, and that's the reality of what happens in JMSC, if the candidate is chosen beforehand, the people, they're going to go through without any problem. And it doesn't matter. They'll pass through anybody they want, no matter how bad they are, and they'll keep out anybody they want, no matter how good they are. And that is the flaw. That it's patronage. It is not merit. And I'll talk about that in a second, too. So here's some cases I want to go through, and I'm going to go through them a lot faster, I promise, but I needed to preface my comments. State versus David Morgan. Representative Rutherford was in here a minute ago. That was his case. This was an individual. I have his pre-sentence investigation, and in 30 years, there have only been 2 pre-sentence investigations I've ever even heard of, both of them involving Representative Rutherford's clients. One, the one in Richland that Solicitor talked about, and this one in York. So this is the pre-sentence investigation. He was charged with shooting up a nightclub parking lot. Okay, multiple people out there, and he just opened fire in the parking lot. He's charged with attempted murder and a bunch of other charges, possession of a firearm by a felon and so forth. His record starts at the bottom of this page. This is 6 separate criminal events here, starting in 1987. The crime happened in 2015. Turn it around. This is the other 15 criminal events that resulted in convictions, all the way up to 2013. Okay? He's done 10 years in prison at one point for an aggravated assault. He's done a total of, from 1995 to 2006, he was in the South Carolina Department of Corrections for a variety of bad offenses, robbery, burglary, grand larceny. So he comes into court, and this is one of those cases where everybody thinks, you know, that it's going to be a jail time. Everybody thinks this guy's got to go to jail, and he's going to go to jail for a long time with a record like that and doing what he did. He comes into court with his attorney, Mr. Rutherford, and stands up, and they start talking about, you know, this and that, and then he pleads guilty, and they ask for a pre-sentence investigation. He pled guilty in February of 2017. The pre-sentence investigation was issued, and we couldn't get Mr. Rutherford back until March, the end of March in 2018. Now, the defendant is on house arrest as part of his bond that Mr. Rutherford got him. And under the law y'all passed, if you're in your house under electronic monitoring, you can ask the court to have that applied to your sentence. So he got to spend 15 extra months out of jail in his home, which we showed the court how he routinely flouted that, didn't charge it, nobody knew where he was. It was a joke. And he got a 3-year sentence with credit for 2 years that he spent sitting in his living room for shooting up a club at 2 a.m. With that kind of record. Nobody else could have accomplished that but Mr. Rutherford. Second case I want to talk about, I brought these. Speaker Pope, you will recall, we had a one lawyer who practiced in Union regularly. We could never get him to come to court. We docket his cases over and over again. He's a legislator lawyer from the upstate. he just ignored it. He wouldn't call. You'd call him. He wouldn't call back. It was like he treated court as being optional. It wasn't just protection. He wouldn't come in the fall. He would never come. We couldn't get him to come to court. It got so bad that I would sit there with victims waiting to get called. I would sit there and just say, Your Honor, I know he's not coming. It's obvious he's not coming. His office says they don't know where he is and they don't know how to get a hold of him. Nobody knows where this guy's at. I just started standing up and holding forth on the record and ordering the transcript to try to document this outrage somehow. I found 2 of them, and I'll give those to you. The last one was from 2013 in the case DeMorris Davis. I had told this senator, I said, you pick the day in October. I'll be there any day. I'll have the victims there. We'll do the plea. You schedule it. Representative Bamberg, he had the power of the docket. I just gave it to him. For God's sakes, if you just come to court and tell me when you're coming, we'll do the plea on the day of your choosing. So we all show up on that day. His client sitting on the front row. No sign of him. We call. No answer. I go to the judge. Victims, I got the defendant. What are we doing here? He says, let me have my clerk call him. The secretary at his law firm says, he's not here, and I don't know how to get a hold of him. He has my number blocked, I think is what she said, and so that only he can call me. So nobody knew where this guy was. I know, it's ridiculous, it's laughable. So after multiple calls, we finally hear from him at about 2:30. His clerk, the judge's clerk, gets up from behind the bench and holds up his phone and looks at me like, it's him. So I run back. Are we going to be graced with his presence for a guilty plea? No. He said, I've been busy. I've got a friend who's sick and I've been trying to help him. How dare you call and harass me? To the judge's clerk. The judge's clerk. I could hear him yelling through the speaker on the phone. And he said, what do I have to do? Call Chief Justice Toll? Do I have to do that? And this kid who's like 6 months out of law school is sitting there going, you could see him getting pale. He was horrified. He didn't know what to say. He's just a kid. He was just doing what the judge told him to do. There was a case, I believe, I was reminded of, where the guy he represented was sitting in jail. We had a time served offer. This guy could have got out of jail if he would just show up to do the plea, and he sat in jail for an extra 7 months because we couldn't get him there to do the plea. I had forgotten all about that. There's no way you can tell me, because no other lawyer, if I'm 15 minutes late, I feel bad. But there's no other lawyer. If a public defender just stopped coming to court, do you think that would be the result? Everybody just shrugs and goes, well, what are we to do? This same fellow represented an individual in Greenwood. I'll try to tell you that story, but before I do, I want to go back to Representative Rutherford. I'm sorry he's a target-rich environment, but he keeps on giving. This was a case that happened in the 11th Circuit, Solicitor Hubbard told me about. In this case, they again told him this was an old case. They tried to schedule it for trial. They finally said, just give me, here's the 2 dates in October, the 2 weeks we have court. Pick one of them. We'll try it then. So he picked the October 15th. They get to 2 weeks out, and he files a continuance motion and demands to be heard. He says, I was never notified of this trial. I have no notification of it. This was the Cookout killing in Lexington. It got a lot of press. 18-year-old kid stabbed in the chest one time, right in the heart. 18-year-old kid lured over to the car. The guy in the car had a beef with him. Kid had done nothing wrong, just lured him over there and one shot out of the window with a knife and killed him right there. They found the knife buried in the neighbor's backyard of the defendant. He called over and said, I had no notice. When Solicitor Hubbard stood up and held up the email and said, here's the email you sent saying October 15th, you picked the day. He looked and said, are you calling me a liar? And told him to shut up and sit down. The judge said, well, maybe the email went to the wrong address. To which Solicitor Hubbard said, well, how did he reply then? How is it possible that he replied with his signature on there? How is that possible? Obviously it didn't go to, but the judge was so concerned, he didn't want to say anything to upset Mr. Rutherford. So he just eventually, after talking and talking, they said, well, we'll schedule the hearing for the continuance for October 24th, 9 days after the trial was supposed to start. So we're giving you the continuance by scheduling the motion for after the fact. My lawyer from Union, I'm trying to go through the facts really fast. A guy charged in 2 murders and attempted murder. This is Jeremy Trevios Saxon, horrible, horrible gang member up there, multiple drug distributions, assaulting police officers while resisting arrest, throwing urine on detention center officers who, thank God, we have people willing to do that. It's a hard job. Horrible person. He's arrested, taken to jail, and they dicker back and forth with the public defender trying to get it to trial. Couple of years into the case, they finally get a trial date, and they're prepared. A week before the trial, the legislator lawyer comes down, files a notice, which happens too many times. We're all ready to go to trial, and the legislator lawyer comes in, files a notice saying, I represent this guy. That's an automatic, guaranteed continuance. The case will be put off, and sure enough it was. He managed to wheedle and cajole and talk to 2 different judges over the next 6 months, and finally got this guy who has a terrible record and was charged with stabbing a man in the throat, nearly died, but for immediate medical intervention that was fortunately close by, that guy would have been dead. The guy got probation. Again, looking at results that nobody else would have received. This gang member, and the victim survived in that case, but as a sad postscript, he was murdered shortly after that by another gang member from the same gang as Mr. Saxon. The criminals know that you go to a legislator lawyer, and that's who's going to help you. They all know that too. We had 30 kilos of fentanyl seized in York County last year. In the fall, 30 kilos. These people had real property that they owned, houses, land. They owned fancy cars. One of them was wearing a $100,000 Cartier wristwatch, lots of money. The top 3 guys, the ringleaders, all 3 of them hired legislator lawyers, one of whom was on the JMSC. They know who to go to for help, but in a happy postscript, we got the case moved to federal court, where a federal judge doesn't give a rat's butt about whether you're in the legislature. When they schedule a case for trial, you're going to be there. So that is a good contrast with the problems we're talking about. There's so many problems. We actually had to pare this lift. You can't imagine how many stories were left on the cutting room floor. And I feel bad. I know my folks are working hard right now. We're trying cases. Oh, Mr. Caskey isn't here. We just got a verdict about 45 minutes ago on a homicide by child abuse case, a guilty verdict on a 4-year-old case. We're working hard to clear the backlog, and we actually have our numbers down to what they were right at the time COVID hit. So we're awfully proud of that. We've had incidents where legislator lawyers come in and tell the judge, I know what the legislative intent was, Your Honor, when this statute was passed because I'm in the legislature. Countless stories of legislators coming in and talking to judges and saying, say, Judge, aren't you up for re-election next year? What would be the point of that? Why would you want to do that? Except to remind them who holds the whip hand, who is in charge here. All the way to stories where legislator lawyers walk out and tell you, here's what the sentence is going to be on this plea we're about to do. And I don't know how they knew that, but it was awfully coincidental that the judge came out and gave a sentence that was exactly what the legislator lawyer said it was going to be. I'm not a witness to anything, but he's either awfully good, he's Nostradamus, or so. Those are the cases I want to talk about. The last one I want to talk about is State versus Hawthorne. And this is, for me, a great example. The thing you need to know about State versus Hawthorne is he was charged with the murder of Larry Vaughn, a veteran, retired police officer, a lieutenant who just retired recently from the Rock Hill Police Department, found beaten to death in his apartment. He Mr. Hawthorne was arrested shortly thereafter. Fortunately, there were witnesses who were able to identify him as being at the scene. They found him. He's still, they were able to gather good evidence and make a quick arrest on the case. He hires Jack Swirling. For those of you that don't practice in the criminal field, Jack Swirling, if you have him in your corner, it's like having, you've got the Muhammad Ali of the criminal defense bar fighting for you. He's a great lawyer, has the respect of everybody on both sides of the courtroom, prosecutors and defense. Everybody likes Jack, and everybody respects Jack. He is feared. He is a great lawyer. So he hires a good lawyer to go and represent him. Jack takes him into court, tries to get him a bond. No bond. Terrible crime, brutal beating, bond denied. Some months go by, and all of a sudden, we get in November of 2022 an email from Mr. Rutherford's law firm saying that they want to schedule a bond hearing. We didn't know Mr. Rutherford was even involved in the case. We found out about it maybe a few weeks before that, but he just popped up for the purposes of trying to secure him a bond. Not only does he want a bond hearing, they tell us exactly what day they want the bond hearing and that they want it in the morning of that court week, Tuesday in the morning on the 13th. So obviously, victims have rights too, believe it or not, they do, and we have to notify them and people who want to be there. And Jack Swirling has rights because he's the guy's lawyer. He's the one actually listed as being his attorney. So we noticed that Jack is not, well, we don't, because I conflicted the case to the Seventh Circuit. Solicitor Barnett's office is handling this case. We noticed that Jack Swirling isn't listed on that request for a bond hearing, so he's added to the thing, and Jack comes back and says, I'm in a murder trial that week, I can't do it. So we think it's off, if Jack can't be there. Todd writes back and curiously deletes Jack's email off of that email list. He's not listed on that. Writes back and says, Mr. Rutherford is waiving Mr. Swirling's presence. Spencer catches that, Spencer Smith, the attorney prosecuting it, and says, what about Mr. Swirling? Is he waiving his presence at the bond hearing? Because I think we need to hear from him. And Jack says in a subsequent email, apparently they want to move forward even if I can't be there. I will waive my presence, assuming I can get a written request from the defendant and his parents. Thanks for checking with me. To Spencer, because nobody else checked with him. The next email we get is December 1st. Here is the waiver. We don't need Jack. So we start to go forward. I reach out to the victims. I'm doing the victim piece. I call the victims. The daughter of the dead police officer is in college, and she's in final exams that week. So the family says, please, can you put this off? Even talking about it's going to disrupt her exams. We're afraid it's going to have a bad impact on her finals. She's very upset about the whole thing, understandably. Please, can we get this delayed to a later date? So we tell them that, Mr. Rutherford's office, and they say, and in addition to that, I wanted to be there, and so did Sheriff Tolson. We tell the defense that and say, look, the child can't be there and really wants to be there. She's in college, final exams. It doesn't matter. All they're entitled to is notice, they say. I'm going to call the administrative judge. Now, there was no email from the administrative judge, but at some point that week, I was told, that I could tell the victims to stand down. The chief administrative judge said, we're not going to have the hearing if the child can't be there. So I told them that. Then at Friday at 3 p.m., I get another email saying that a visiting judge who is also going to be there that week has been contacted and has said that he will hear it. I call the chief judge back and say, wait a minute, you said we're not going to do this. I've already told the family no. And he says, well, I don't want to step on this other judge's toes. And I had to think to myself, does he not want to step on the other judge's toes, or does he not want to step on Mr. Rutherford's toes? Who's really, who's he worried about offending? Because he's up for re-election as well this year. The hearing went forward. Bond, which had previously been denied, is set. The defendant is released. No change in circumstances, nothing to justify a new bond. Then we find out from jail calls between the mother of the defendant and the defendant, we hear her version of her conversations with Mr. Rutherford. She says Todd says we just need to be patient. We're waiting for the right judge. And it's good that Todd has connections. I wasn't a party to that conversation, but everybody who heard that in the law enforcement community immediately said, what kind of connections does he have? And does he have influence over a judge? How is it that this man couldn't get a bond with Jack Swirling, but Todd shows up and all of a sudden he's going home with his mom? And what do these calls mean? Perception is reality. And as I think you said last week, Mr. Speaker, it not only has to be right, it has to look right. My last, thank you. Yeah, these are all the emails. You have a copy of this PowerPoint so you can see them. I can't read them from there. My last case that I want to study, this is Christy Harrington on the left and Judge Tommy Russo on the right. And I'm grateful to have Judge Russo in the room with us today. He came here, and I'm sure he'd be happy to talk to you about his experience with JMSC. His JMSC hearing was set. He was a great judge. I practiced in front of him. I never heard a single bad thing about Tommy Russo when he was on the bench. Everybody respected him. He had a good temperament. He was efficient, worked hard, showed up, worked all day. Everything you could possibly ask for in a judge. He was up for re-election in 2019. The election would have taken place in early 2020, but his screening was set for November the 18th of 2019. Nobody had filed in opposition. There were no complaints. He met with the staff attorney assigned to his case the month before his screening, in mid to, first, maybe second, third week in October. No issues. Asked a few questions about some of the things on his application, but in his mind, it was the same as it had ever been. I think he'd been screened 3 or 4 times, and there was no indication that there was going to be a problem at all. No, they're going to really grill you about this. Everything was fine. They're probably going to ask you questions about that, but you just tell them this, and this is all good. So he's thinking it's great. But there were issues. On the right is an order that he signed in a case, Larios versus the estate of Larios versus South Carolina Electric and Gas, case out of Colleton County. I'm going to talk about that for a minute. Larios was a case that Judge Russo presided over. It was a wrongful death action. An individual who was a landscaper from Mexico had been electrocuted, and the case was tried in Colleton County in front of Judge Russo, and a $21 million verdict was rendered for the plaintiff. It was tried by a firm out of Charleston. Just no lawyer legislators involved, no legislators involved in the case whatsoever, all the way through the verdict. September 27, $21 million. October 8th, the defendant files a motion for a new trial. Basically, a motion for a new trial is, let's set that aside. This can't be right. We need a do-over. This doesn't make sense in light of what the facts were in the case. This is way too much money, and this needs to be reconsidered. I want a new trial. On October 18th, the chairman of the JMSC, Representative Merle Smith, was hired and made an appearance in the case for the first time. Had no idea about the facts of the case prior to that. He wasn't a trial lawyer in the case. He had no involvement with it whatsoever. But suddenly, he's hired to litigate and defend the $21 million verdict and try to protect these lawyers' $21 million winning from being overturned in this motion for a new trial. The next week, the motion for the plaintiff is argued by Chairman Smith. On November 1st, Judge Russo issues an order granting the motion for a new trial. In other words, ruling against the chairman. Now fast forward to the screening day, Monday the 18th. Judge Russo shows up for his screening. Still nothing unusual has been raised. Nobody said anything to him. But for some reason, the chairman has recused himself. Thank you. For some reason, the chairman has recused himself from participating in Judge Russo's screening, which is odd because they have no other connection that would justify that. But he's not there. They asked him a few questions about a disciplinary complaint that had been filed against him regarding a Facebook post. And they say, would you mind, and it's fairly friendly, a conversation on the 18th, would you mind very much allowing us to look at 6 years of your Facebook history? We want to look back through that. And while we're at it, would you mind getting and allowing us to see the disciplinary counsel's record? Now, you heard about the disciplinary counsel from Solicitor Pasco. What he didn't explain is the disciplinary counsel is to lawyers what the boogeyman is to children, okay? That's the scary monster hiding under the bed who's going to grab your ankle if you get out of bed. This is the man who can take your law license and deprive you of your ability to make money. The disciplinary counsel is somebody you never want to get a letter from. So, you know, I think that's important context for his story, and you need to understand that as to why it was unusual that he was at Christy Harrington's screening. But they asked to see the file, and he said, that's fine, I got nothing to hide, and here's my 6 years of Facebook. I don't do a lot on it, but take a look at it. And the Facebook post that they were concerned about was some post that he'd made, not on his own Facebook, but a comment in reply to somebody else's, which basically said, people are hypocritical. You know, that they say one thing here, but then they do another thing there. It wasn't, as postings go on Facebook, it was tame. So he says fine, and they say great. And the other thing that's unusual you need to know is that when he got there, after they asked a few questions, they went into executive session, which there's nobody here now from the JMSC, but I don't know why you go into executive session if you're the JMSC. I thought if you're a public body, you only go into executive session to get legal advice, to discuss a pending contract. There's very few things that you can go into executive session. But they kicked everybody out, and they stayed in executive session when they told him to come back on the 18th. They said, you know, come on back on the 18th, or the 20th rather, and we're going to have further conversation after we've reviewed your Facebook posts. He comes back, they're still in executive session, and the assault on him begins immediately, just like Solicitor Pasco described for Harrington. They attack him, they ridicule him, they berate and condemn him, call him all sorts of horrible things, and after beating on him for an extended period of time, Mr. Rutherford looks at him. There's been no vote, there's been no deliberations, nothing. Mr. Rutherford looks at him and says, you're not making it out of screening. The only thing you have to decide is whether you want us to come out of executive session and humiliate you in public, or you want to withdraw. And he is shell-shocked. He can't even think. And he says, I need to talk to my wife. And they said, we'll give you 5 minutes to discuss whether or not you should end your judicial career, a distinguished judicial career. 5 minutes, go call your wife, and then come back and tell us what you want to do. Because we're moving on. So he withdrew. He surrendered his robe. And now I don't know what motivated this sudden change of heart. Why did they all of a sudden have problems with him when a month before everything was on cruise control and he was coming in for a soft landing? I have no idea what goes on in people's minds, but perception is reality, and it not only has to be right, it has to look right. And I ask you, does this look right to you? 3 weeks after he shoots down a $21 million verdict that's being defended by the chairman of the JMSC, his legal career, his judicial career is in tatters, and he is flamed out, blindsided. You got them. Yep. Hit it. He was replaced a year later by a man named Stephen DeBerry. I never practiced in front of Stephen DeBerry, maybe a fine fellow, I don't know. But he was elected the next year to replace Judge Russo. This was an article written by John Monk with the state newspaper that he went to cover the JMSC hearings for for Judge Russo's replacement. 14 people were screened, 3 came out, including Mr. DeBerry and 2 other individuals. And as I said, Mr. DeBerry won. Go ahead. Mr. DeBerry, a Florence lawyer and member of the Florence County Council. DeBerry is first cousin to Representative Smith, the chairman of the JMSC. Must be right, must look right. I don't know what's going on. Maybe he was the best candidate out of the 14. But how do you think that looks to the public? How do you think it looks to Judge Russo? Interestingly, in a rare moment of candor, complete and total shocking candor from Mr. Rutherford, talking about the JMSC process, he says, if you find a lawyer coming in here that doesn't have connections, I promise you they won't make it out. We have a small legal community. If somebody came in here and didn't have a connection to anybody in this room, it would be odd. I don't know how they'd make it out. What in the world? In that brief shining moment, Mr. Rutherford kindly showed everybody this is what it's about. And in a beautiful lead paragraph from Mr. Monk, hit it if I think it's the next. I read this and just had to laugh out loud. This is his lead. Ancestors, family pedigrees, old friendships, college ties, easy cheer, and even merit were all part of the mix last week. Like, hey, they even talked about merit. But just like Mr. Rutherford said, it's not what you know, it's who you know. If Mr. Rutherford's right, and I submit that he is, Benjamin Cardozo, learned hand, Antonin Scalia, Ruth Bader Ginsburg could all submit for judge in South Carolina, and they wouldn't stand a chance, because none of those people know anybody in that room. So what do? Again, I don't know how you defend that, but what do? How do we go forward? And I know you want recommendations, and I know the 3 areas of concern, and I appreciate the fact that this commission exists to have these public hearings. So, as far as magistrates, and I'll say I have not had time to sit down with my colleagues and discuss all this stuff. We had our solicitors conference and we're meeting next month, but I haven't had a chance. So this is Kevin's opinion on what we should do. Some of my colleagues may disagree, but I
think you provided this to staff, but it was today. I'm not sure that,
That's
that
right.
members have a copy, but I'll make sure that all members get a copy of the recommendations.
So, and I've talked about this before, I believe, with you, Speaker Pope. We've talked about, how could we change things? How do we make things better? Well, General Sessions Court is overrun. We've got a lot of cases in General Sessions Court. That's why our dockets are as bad as they are. We have a ton of smaller cases that are there, 3 years or less. I think that magistrate court should follow, and we should follow what other states have done, many other states, and create an intermediate court with a jurisdiction up to 3 years. Call it a district court. And that the district judge needs to be a lawyer. They can hear all those cases can be taken out of General Sessions Court and shifted down to district court. Allow the district court judges to hire magistrates who can hear the smaller cases, 30 days, just like we have now. But their jurisdiction would be limited to 30 days or less, and they don't have to be lawyers. They could run traffic court, in other words. The thousands of tickets that roll through our magistrate courts throughout the state. I think the number of judges in a county should be dictated by population so that you can look and see how many people they have. This is about how many district judges they need. District judges should be hired by the senior circuit judge and supervised by that person. Then they're only accountable to another judge. That judge makes sure that cases are being moved in a timely fashion, and you can establish evaluative criteria. How about that? We say, how long does it take you to move a case in court? How quickly are you setting bonds? Are you getting warrants out in a timely fashion? How many trials do you have versus pleas? The next one, JMSC, appointed by the governor. I'm going to talk a little bit more about the JMSC. I think the governor needs to exclusively control who's on the JMSC and the screening function. And I'll talk about this as I go into my next page as well. I think you could have term limits, and I'm sorry Mr. Caskey isn't here. I enjoyed his line of questioning with the Attorney General earlier today. Term limits for members would solve a lot of the problems that they were talking about. Why don't we have retired judges and senior members of the bar who are retired after long and fruitful careers practicing law? Let them screen judges. They're not going to go back in front of them. Let those guys screen them and have a pool of them, 25 or 30, and nobody knows who you're going to screen until you show up. And they say, here you go. Here's all the stuff. We're putting 3 of you on this judge, 3 on this judge. Let them screen them and then term limit them out so you're never screening the same judge twice. Make sure that they're open and televised. The public should be able to see these. No executive sessions. Nobody should go through what Judge Russo went through. You could consider possibly just making their positions advisory only, that doesn't kill the candidacy, that it still comes forward for consideration. And lastly, consider extending the time, the period of time for a judge, the term from 6 to 8 years. And there's a good reason for that, and I'll tell you in a minute on the next slide. The election process, the issue isn't the selection process. The issue is the reselection process. Every judge in this state knows they have to come back to the legislature every so often and beg for their job. That is the sword of Damocles that hangs over every judge, and that is the authority and the power that certain legislator, lawyers, JMSC members have to exploit their influence over these judges and influence and pressure them into getting some of the results we've been talking about. Once you've been chosen as a judge, you should not have to come back to the legislature. That solves all the problems. Now you're on the bench, and you should be accountable to one of 2 different scenarios. Scenario 1, which many states do, is a retention election by the public. I trust the public to make these decisions. They elected all of us, right? Why shouldn't they be trusted to decide whether their judges are doing a good job? This isn't a contested election. People keep saying, it's contested elections they want. This is terrible. We're going to do like North Carolina. Money's going to corrupt the process. We're not talking about a contested election. Up or down, should we keep this judge or not? And if they say no, it goes back through the process, screened again, chosen, preferably by the governor, but possibly by the legislature, and then back out to serve until the public says you're not doing a good job. You could also extend the term to 8 years, as I said earlier, and let the governor reappoint instead of retention elections. That way, since you're term limited as a governor, you only ever get 1 crack at a judge. You never can influence them again. Once you've reappointed them, you're done. Although I'll say, I think the threat of governors abusing their system and influencing judges improperly is kind of overblown, because in my 32 years, I've never seen a governor walk into court with his arm around a client and a briefcase in the other hand to litigate his case. So, reselection by the legislature is the persistent threat to judicial independence in South Carolina. Hamilton Federalist 78, just because everybody else talked about 51, I think 78 needs to get a little play, so I threw it in there. He's quoting Montesquieu, and this is Alexander Hamilton. I agree that there is no liberty if the power of judging be not separated from the legislative and executive powers. And it proves in the last place that as liberty can have nothing to fear from the judiciary alone, but would have everything to fear from its union with either of the other departments. While still not perfect, retention elections or subsequent reappointment by successive governors offers the greatest degree of judicial independence, short of life tenure, which I say I wouldn't want life tenure either for South Carolina, but I'd take it over what we have now. Lastly, on the way of suggestions, the vesting clause of Article 3 from the United States Constitution, the highlighted part, just talks about setting up courts and so forth. But the last part was really interesting. And these judges shall at stated times receive for their services a compensation, a salary, of course, which shall not be diminished during their continuance in office. Can't cut their salaries, because the founding fathers recognized, well, they might not be able to run them off if they have life tenure, but if they cut their salary to $1 a year, they ain't gonna stick around long, because they gotta eat. So they protected them from the power of the purse. And I believe that is another thing that the legislature can do to protect the judicial independence in South Carolina. And that is making sure that the judicial budget is never less than the previous year or a set percentage of the total budget, whichever is greater, so that it can never be, they can never be punished for not doing the bidding of the legislature. The legislature has to set the budget. That is a proper function of a legislator, levying taxes and appropriating money. But to cut the budget and punish somebody because they don't do what you want, or even have that threat, because it was previously asked by Mr. Caskey and Mr. Pasco, why would Justice Beatty worry? He's not going to have to come up for re-election. No, he's not. But that was January. What happens in January in the legislature? It's the start of budget season. And who comes over here? Who represents the unified justice system in South Carolina? The Chief Justice. His office is the one that has to fight and scrap for money, just like every other agency. So making sure that they can't be tampered with. Now, of course, if times of lean come and we have another great recession and cuts have to be made, cuts have to be made. As long as the cuts aren't made greater than anybody else. As long as they're equal to everybody else's. So it's not like, oh, we're gonna cut SLED 5%, but we're cutting the judiciary 30%. That wouldn't be acceptable. So I think providing some mechanism to protect the independence of the judiciary from influence through the power of the purse. I just have a few closing thoughts, and I don't even know how much I've blathered on. I have 15 minutes for questions. Yes, sir. Yes, sir. I really, the public, in light of recent events, is justifiably outraged. Everywhere I go and talk about this, they are concerned. And when they finally, the ones who don't know about it, when you explain it to them, they are red-faced. They can't believe that this is the state of affairs in South Carolina. As bad as the system is for screening, as bad as that is, the patronage is just as bad. Family members, it can't be a coincidence that so many family members of legislators end up in judicial positions. If you have any reservations about whether or not the system has any value, I would ask you to think about Solicitor Pasco's description of the events at Christy Harrington's. The fact that Chairman Rankin or whoever had a staffer call over to the Supreme Court and summon the disciplinary council to a hearing, sit him in that room, see him in the back, and say, no, 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 no. Come up and sit up front so she can get a good look at the boogeyman. You get up here. Literally sat him up front, staged him like a prop on the set of his show hearing, is not just clear and convincing evidence, it is beyond any doubt the arrogance and contempt, the sense that they are above the law, that they could do that. Calling the disciplinary council, an officer of the Supreme Court, and bringing them over there to intimidate a judge is appalling. They say the only thing necessary for the triumph of evil is for good men to do nothing. You are at a fork in the road. If all you end up doing is adding a couple, 3 people that the governor can appoint, maybe increasing from 3 to 5 the number of people who get reported out, you're just rearranging the furniture and putting another coat of paint on the walls. You're changing nothing. Even if you took all the legislators off the JMSC, but left the appointment power in the legislature so that they're the legislature's people, you do nothing. You actually make it harder for us to figure out what's going on because they have one layer of insulation from accountability. It's not them doing it, it's their stooge. That would be unacceptable too. The legislature needs to divide the responsibility for selecting a judge with the governor's office, and then put the power in the hands of the people to decide whether their judges are doing a good job for them. Thank you.
Ladies and gentlemen, so we got about 15 minutes from that hard stop. We're 15 minutes past our 2:30 hard stop. We're heading to 3. I'll let you know when it's 3 and we'll figure out where we are from there. But Ms. Wetmore is recognized.
Thank you, Mr. Chair, and thank you, Solicitor, both solicitors for joining us as well, and recognize Solicitor Scarlett Wilson here as well. Thank you all for being here and for your interest in the subject. I know a number of solicitors, of course, Scarlett's my solicitor. So I want to start by asking, well, let me start with a caveat. I think all of us up here, we've said this over and over again, we want the same thing. Solicitor Pasco, I hope you unintentionally mischaracterized my comments earlier. I'm not questioning whether or not Democrats want change. I think we all up here want something, and I think we're all committed to taking some actions here. What I'm trying to question is whether or not we're going to create any new problems based on the changes we make. And what I'm trying to avoid is making sure that we don't unintentionally create a new and different problem with any of the proposed changes. So I'm trying to vet those changes as carefully as we can. You know, I heard you talk about if the legislature has appointment power, it would be a stooge. To me, that speaks exactly to my point with that appointment power moving somewhere else. I don't understand how, you know, I recognize, I think, you know, I think having maybe, a retired judge or two, that makes sense to me. But at some point, either because they are members of a firm, someone always has influence. A retired judge is going to have members of their firm before them. A retired attorney is going to have members of their firm behind them. They're going to have their kids. They're going to have, if it's the governor's office, they're going to have their staff or their appointees. At some point, someone always has influence. And so what I'm hearing is that we don't like the who. It might help me understand how we can avoid, in the scenarios you've laid out, someone having influence.
Well, it's always possible, and all you can do is minimize it, which we can certainly do a better job of minimizing it from what we're doing now. But what I think you could do, there's multiple ways you could skin the cat. One of the things you could do, for example, is create pools of senior retired lawyers and retired judges, upstate, Midlands, Low Country. And if you're in the Low Country, you screen the judges who are applying from the upstate, and you're picked at random. Yeah. You don't even know which judge you're going to be screening until you walk in the room, and then the judge walks in and sits down.
I like that.
The ability to come in and influence those 3 people when they don't even know who it's going to be is greatly minimized, especially from what we have now.
Yeah, see, that's constructive. Thank you. Yes, second question would be, I hear a lot of talk about this idea that there's the opportunity for influence or the appearance of influence. And I think all of the cases that you've named, or a lot of them anyway, there's an appearance for everything we do. I mean, you and I are both elected publicly, and I think we would probably agree the worst part of that is fundraising. Is there an appearance of influence when I meet with a donor, if you meet with a donor, right? I just think that to say that the appearance of influence, at some point, don't we have to trust that there are backstops, that there is the ODC, that we do have an ethics process or these judicial discipline or lawyer discipline, all of the scenarios you've described, just like when, someone comes to me and they say, this person was unfairly killed in the jail. I don't know, I'm just using an example here. Well, we have a process for that, right? And I encourage them to go through that process, right? If it was illegal, then they should, then the justice system will handle that. Just like if, here we have a process, wouldn't strengthening that process more effectively address the egregious cases you've described today?
I don't think it would more effectively address it. I think that strengthening those processes is a good thing and should be done. I'm not suggesting that in any way, shape, or form, but I don't think strengthening those processes alleviates us of the responsibility from removing the infirmities that exist in the existing system.
Okay. I'll ask you the same question I asked Attorney General Wilson. When did we start trying to be Washington, D.C.? I mean, if you had told me that we would come into this hearing today and say that the South Carolina Constitution had just gotten it flat wrong, I've never heard us have that conversation in any other context of saying, we should do it more like the federal system. Is this the only issue in which the South Carolina Constitution has just got it flat wrong?
Well, I don't think we're trying to become more like the federal system. If we were, it would be governor appoints, legislature confirms, and a lifetime tenure.
But I mean, we agree that since the 1700s, the South Carolina Constitution has put the power for electing judges within, and because of the history of our state, squarely within the power of the legislature.
I think
Article
it's
5 in several different sections.
maybe the 1895 Constitution.
It was in the 1737 and the
Well,
1767.
you read the article, I'm sure that
Yes,
you probably know
yes.
better. Dean Wilcox is a smart guy. I'm sure he drilled down on that.
Yeah.
But I don't think that just because Washington has other problems doesn't mean we can't look to them for good advice on some things, and especially when our system that we currently have is as deeply flawed as it is. I don't think we should just look to Washington. Unfortunately, we're not going to hear from Professor Fitzpatrick, whose area of expertise is judicial selection from Vanderbilt Law School.
And was in fact my professor in law school, so
Was
thank
he
you.
really?
Yes.
Yeah, super smart guy. I felt smarter just reading his biography. I mean, the first in his class in Harvard, clerked for Justice Antonin Scalia, obviously a very capable man. So, the Tennessee just completely revamped how they select judges. They've done a lot of spade work on this, and I'm sure they have a lot of useful information they could share. We don't just have to look to Washington. We could look other places, but there are many, many states that do it just the way I described. It's called the Missouri Plan, and the governor selects, legislature confirms, and then people ultimately up or down in publicly funded elections. Oddly enough, in many cases, the government funds and gives the judge a certain amount of money to make the case for why they should continue, so the judge doesn't have to raise money.
And I'm not disagreeing that there are other models, some better than ours, some worse than ours. What I am saying is that since the beginning of our state, this is the way South Carolina has done it, and I've just never before heard us say so clearly that we just got it dead wrong. And I hear you, and I think it's up for debate. I think certainly some of the changes you're suggesting would require constitutional amendments. I don't know if that's within the scope of what we have the ability to handle right now. All we can handle are statutory changes. But certainly, I'm just surprised, I guess. It's more of a comment than a question.
We do have a general election coming up next year, so constitutional changes are in the, they are possible. So it could happen. I mean, I would say something that Solicitor Pasco said. It definitely, I think, part of the problem is there's been this climate of fear. Nobody wants to talk about this sort of thing. And just the recent events of the last year, one after the other, cascading, coming down, has just driven the issue to the front. And people are starting to go, what in the world is going on in these courtrooms?
Well, and listen, I was a prosecutor when it was very trendy to accuse prosecutors of misconduct. I'm sure you were there too.
It still is.
Because of cherry-picked stories in the media. And so I would certainly submit that on the whole, to me, in my 15 years in the courtroom, it seems like we're getting it right. It seems like it's easy to drive a narrative of fear if we want to. And so I would submit that just like prosecutors get attacked unfairly, we have to very carefully look. The reason we keep asking for data is because we have to carefully look at the bigger picture.
Can I address something, Representative Wetmore? I've got a very good crackerjack law clerk by the name of Alan Wilson, and I had him text me some information. With regards to the JMSC, let me just get one thing clear. That's relatively new. That hadn't been around since the 1700s.
No,
That was
1975. Yes.
1996.
The
And
bar had it
ratified
in 75, you're right.
and ratified in 1997. And we're just talking about the first step today, which is the easy step. And again, I don't understand why it's difficult when you hear stories about Judge Harrington and Judge Russo that we need to change the JMSC. All we're asking for today is take the legislators off the JMSC. That's it. It's a very simple fix.
I think, you and Solicitor Brackett might be asking for two different things. And
No, he went further. He's much smarter than I am on that stuff, so he's telling you what to do down the road as well.
Fair enough, but what
for
my
today.
questions were directed at were not simply that one simple fix.
Absolutely. But for today, what we're asking for is to take away legislative control from the JMSC, which is a relatively new thing.
That's certainly the easiest thing. It could be on the governor's desk by the end of January if the will was there.
Thank you.
Brackett's going to snatch defeat from the jaws of victory if he keeps on, I think. Okay, so our next questioner is Mr. Bamberg. I've never known Justin ask a 3-minute question, so we have woefully underestimated our hard stop at 2:30, even 3. I know members have places they've committed to and they have to be. I appreciate it. I gave you guys free rein to escape, and some of you even made the mistake of coming back, General. So I think in talking to my co-chair, Weston Newton, and we'll get the feel for the panel at some point. We've got Thanksgiving next week. I think we will then come back the 24th. That was the week, the day we were originally going to do citizen hearings. I think we will try to put in a full day, and is it 28th? 28th, my bad, 28th. Yes, committee, I will buy you some lunch if you will come and work all day. So I just wanted to I had another pack of crackers, Gilda, if you keep it up.
Jelly donuts.
Jelly donuts, yeah. So anyway, what we'll try to do, if you guys are willing, and we'll coordinate with staff, I'd love to hear from the professor, see how Wetmore did in class. And we would like to maybe start again at 10 o'clock, and we'll work into, some point in the afternoon, we'll take a break, and then later afternoon, try to have the citizens. But for those of you that are willing, obviously you got enough interest, you stayed, so if you guys are willing to come back, we'll keep plugging. And if that meets, I would love for us to get as much done the next committee meeting as we can. And then our idea is either that easy work we do, according to Mr. Brackett, we'll either rewrite the Constitution or change all the laws over Christmas, and then we'll have it ready for the governor's signature January, what, 2nd-ish? Is that all right, Mr. Brackett? Yeah.
Somewhere in there.
Okay. Yeah, we got to actually come back in session first to pass it, I guess. I appreciate everybody's participation. I'm telling you, we would not be here. I told the speaker early on that if we're just going through the motions, and I've shared with some of the folks in the audience, if we're just going through the motions, Ms. Cobb-Hunter and I were talking about, I don't want to do it. If we're just going to be here and just talk about it and then do the same thing. I did that for 10 years on tax reform. I hadn't got another good 10 in me. So our intention is to do something. There's no doubt some things are heavier lifts than others. There's some things reasonable people can disagree. I'm assuming after all the things we heard today, we're going to hear more from people off the record, and that'll continue to be. But our intention is to work on it to, in my perfect world, we draft something up that we could present on the House side that would go through judiciary and then hopefully get it over to the Senate. And so we're going to continue to work. I appreciate everybody. And again, we will even keep solicitors if y'all are determined, if nothing bad happens to you in the next couple of weeks. We would even just pick up with our questions where we had left off if the members are willing, if you wish to return. All right. Thank you, guys. Appreciate it. Bye-bye. Ms. Cobb-Hunter has pointed out, we adjourn.